Commissioner Baker, Commissioner Ortiz, Commissioner Wilson, Commissioner Wood,
Here.
Chair Silver.
Here.
Thank you.
Okay, great. Well, before we move on to item 1, public comment for items not on today's agenda, I just wanted to quickly speak to what's going on in Los Angeles right now in LA County. I just wanted to say our thoughts and prayers are with those affected by the wildfires, especially those who've lost their homes or lost loved ones. I'm originally from Los Angeles. I know we have commissioners who are from Los Angeles. I know my fellow commissioner here went to UCLA. This is an event that's impacted lots of people across California and across the country and the world, really. I want to express our deepest gratitude to the brave firefighters and law enforcement and first responders who put themselves in harm's way. I also want to thank, recognize that as the members of the media who've worked tirelessly covering this event and making sure the public's informed of what's going on with these wildfires. So as we go from fighting these fires to recovering from them, let's continue to hold the people of LA in our thoughts as they're going through this. So with that, I want to move on to item number 1, which is going to be public comment for items that are not on today's agenda. Do we have anybody in the room that has public comment for items not on today's agenda? Go ahead, sir. Good morning.
California?
Sir, can you please put your mic on?
Okay.
Thank you.
That better? That better? Got it? Okay. And my town, I've been there for 30 years. My town is really a communist cesspool there. And I've been working so hard to be involved in government and volunteering and so forth over the years. As a former city councilman, I've ran for city council over the last 25 years, 9 times. It's a lot of walking, a lot of sacrifice. Within those 9 years, I actually won by a thin margin. Within a year, I was successfully recalled for using common sense and not going along with my Democrat brethren on the city council. It was all planned out. Since that time, about 10 years ago, I have sued the city of Cotati in federal court for civil rights violations, ADA violations, and more, and I've won both times. They are so upset the fact that I've won against them and resulted in 2 front page stories in the Press Democrat, headline stories. They've continued with retaliation. One of the reasons I'm here today for. My issue here is in the last year, as I ran for city council again, they've continued to retaliate against me in this fashion. They've used city staff and code enforcement to come after me selectively in town. We have a large lawsuit ready to be filed against it for this, but they've used selective enforcement, and I don't feel that your in-kind contribution rules address this very issue that's going on, I think, in other cities. What they've done cleverly, they've used city staff to go after their political opponents by draining down my campaign funds to defend myself in these silly code enforcement hearings, okay? And it's a way to get around the in-kind contribution laws, right? Is to use staff very cleverly to weaponize these departments. I would like you in the future to see what we can do to look at the in-kind contribution rule and how we can try to fix this or address it, okay? The other problem here, why this is so important, is that our district attorney will not prosecute Brown Act violations. They're all in bed with each other in Sonoma County. They're all friends, okay? They've shared meals together. So that you're our last hope to bring some justice to these kind of situations. Because I've been persecuted, and this case has been going on for like 18 months. I wasn't able to campaign this last season. Because it's been going on, it's abuse of the system. It's abuse of the political system. And I'll be back to tell you more later. I'm probably almost out of time. I'll be back later to tell you a little more detail. But as this week for the chairperson, before the city council, I made a presentation that our town should be a sanctuary city for a lot of the fire victims in Los Angeles and what we could do to welcome those people up and help them. I have family coming up to stay with me and so forth soon that were victims. And I got silence. From the Democrats on my council. It just broke my heart, but we're trying to do what we can, Commissioner, and I'll see you soon. Thank you.
Well, thank you for your public comment. I just want to emphasize what we've emphasized at prior meetings, that we are dedicated to cracking down on the misuse of public resources for campaign purpose. And we welcome any sort of proposals from local watchdogs, from other stakeholders on how laws could be changed to more effectively do that. So if you have anything like that, we'd encourage you to send legislative proposals to our legal division. If you or someone you know witnesses a potential misuse of public resources for a campaign purpose, absolutely go ahead and share that with our enforcement division or other law enforcement. I just want to highlight, as you likely already know, that we do have anonymous complaints. You can file a complaint anonymously if you're concerned about retribution. So keep that in mind, and thank you for coming up here today. Commissioners, anything else on that item? Any additional public comment in the room? Go ahead, sir. Last item on there, I just want to clarify, just in case we don't have jurisdiction over Brown Act or in public meeting rules, but I appreciate you bringing that to light. Go ahead, sir.
Certainly. First off, I'd like to start off by thanking Commissioner Baker for her service. I understand you're done at the end of this month, and I'd be remiss if I didn't say thank you for your comments and listening to my past presentations. At your last meeting, your legal staff told you there were limited actions which could be taken by your board. As I told you, there are a few actions which can be taken and will send a loud message to elected officials everywhere who engage in egregious violations of government code over which you hold jurisdiction. I have made copies of the specific code referring to getting personal financial benefit from making decisions as an elected governmental official for each of you, plus one copy for Ms. West. Section 1090 of the Government Code, and this is the copy that I'm talking about. Each one of you should have received it. Section 1090 of the Government Code covers elected officials who enter or are involved in contracts which financially benefit them. I have not copied the entire section. Starting with 1097, I've highlighted the pertinent parts for your consideration. While there's a basic fine of $1,000, the more punitive measure in this section, which is the actual 1097 section, is the ability to prohibit the individuals receiving financial benefit and any and all who aided and abetted that action from ever holding public office again. If you don't think you have some power, there's your power right there. To enable these type of cases to move forward, your staff must contact the DA or State Attorney General to assure your board is not duplicating action already being taken. Evidently, from the tenor of this section, the DA or the AG may also enforce violations, although I have not yet done enough research to find the specific code related to that. Government Code 1097.3 allows your board to go after violators in civil action of the greater or up to $10,000 or 3 times the benefit they receive. I can easily see where the benefit received will be much more than $10,000. A person in my city of Dixon has filed an anonymous complaint regarding just this type of action taken by my council. No action has been taken by your staff in almost 3 years. I will be filing a signed complaint on the same matter in case it's because it was anonymous and they just haven't received any information. But we haven't seen any decisions on your website saying that it was thrown out or whatever. Given all of the outs in the 1090 code section preceding the one which I have provided you, it is clearly evident to me I will have to be doing a lot of work to show you how the intent of the code is being perverted to allow officials to violate the intent of the law. I have not completed my research into actions which you can take or which can be taken under your AdWatch campaign I repeat that simply finding a governmental entity several thousands of dollars when that entity is going to receive millions from a sales tax they promoted with taxpayer dollars will not stop them. I had expected to see this board place a workshop on this agenda to address the matter. I understand from talking to Ms. West that your chief enforcement person is going to be speaking about that at the end of the meeting, but I'm not going to be able to stay that long. In addition, violations of reporting requirements by those campaigning for the barely successful sales tax measure also need to be looked at for the same reason. The benefit outweighs the fine in ongoing salary increases to these individuals, specifically within the fire department. They're the ones that campaign for it. I hope to continue working with your body to remedy these problems through legislative action backed by this body. Thank you very much for listening.
Look forward to working with you. Any other public comment? Okay, go ahead. We have public comment on the phone.
Hi, this is Lori Alderman, and I'm also from Cotati. The two previous speakers are my friends. We really need help down here in Sonoma County and especially the city of Cotati. We have not had a fair election, city election in 10 years because of city staff and in-kind contributions, things like this. The city manager will be on the fundraising committee as an expense for and run the website and then block people. There was a lot. This whole George. Sorry, I have a little bit of a speech disability. Excuse me.
No worries. Go ahead.
This last campaign, we warned them about election interference with this code enforcement action, which has cost, they've spent over $100,000 on one person to go after George Barrett, their political opponent, and in the last year. And so then he couldn't campaign, and because he was out of money paying attorneys, because they have a $1.8 million proposed fine against his house that he has to stay at the hearing level. So he couldn't campaign, he couldn't do anything, and that they knew. It's gone on for 19 months. They knew going into the election. So it was used as a political weapon by the three incumbents, and they were all Democrats. And George was George is conservative. So this kind of stuff. I talked to the registrar of voters, and they know about that in Sonoma County. And the DA won't do anything, but it's out of the purview of the registrar of voters. So I want to. Hopefully you can address this in the future on in-kind and when city staff is involved in election interference or that doesn't directly profit them because it's not covered under your rules. Thank you very much.
Thank you. Do we have any additional public comment? Excellent. Go ahead.
Morning, Commissioners. I'm Stephen Massey. I'm the Director of Technology Services for the San Francisco Ethics Commission. On November 8th, the Ethics Commission's Executive Director, Pat Ford, sent a letter to the FPPC regarding the serious concerns our office has with the implementation of AB 1170. As stated in that letter, San Francisco supports the electronic filing of documents and has been a leader on this issue locally. For more than a decade, 87200 filers in San Francisco have been filing electronically, and the Commission provides the public with both redacted and unredacted versions of Form 700s that are available immediately through our website and public library kiosks. The Commission also provides Form 700 records in parsed datasets. These data sets are a core aspect of transparent government in San Francisco and make Form 700 data easily accessible to the public. These data sets include not just data from 87-200 filers, but all of the city's 5,000 plus filers. Now, if AB 1170 were to require the city's 87-200 filers to file only through the FPPC system, San Francisco's system would be severely disadvantaged, and we would be taking a big step backwards for transparency in the city. Now, currently, San Francisco's 87-200 filers are filing their Form 700s twice, once with the city and again with the FPPC. However, we do not believe this is a viable long-term solution. We would like to meet with representatives from the FPPC and Netfile to figure out a solution. Our staff has been attempting to schedule this meeting for weeks, but no such meeting has yet been scheduled. We would like to engage in this discussion before the FPPC moves forward with developing regulations related to AB 1170, as mentioned in this month's executive staff report. Thank you, and we look forward to working with the FPPC on addressing the issues that exist with the implementation of AB 1170 in a way that honors our shared values, transparency, accountability, and efficient data access. Thank you.
Thank you. So I know, just to clarify, we had a interested persons meeting recently where we had numerous jurisdictions provide us feedback on this transition. I don't know if the commenter is still on the line. Was San Francisco Ethics at that interested persons meeting? But sounds like the commenter is not there. Yeah, it's basically irrelevant. I think it's important to note that, you know, we did have this interested persons meeting, and I know whenever there's a major transition like what we're doing with AB 1170, while there's tremendous benefit to the public in terms of transparency and ease of use of our new system, there's going to be potential issues. And we're working with jurisdictions across the state of California on those, and we're looking forward to discussing this with San Francisco Ethics Commission, and we'll make sure that a time is set for us to discuss those concerns that you just laid out there. Any additional public comment?
Hi, yes, can you hear me?
Yes, you can. Go ahead.
Yes, this is Don Garcia. I'm chief of the Conflict of Interest Lobbyist Division with Los Angeles County. The reason for my call is that my department, the Executive Office of the Board of Supervisors, serves as the filing officer for 12,000 Form 700 filers that come through the county for various school districts, water districts, joint powers authorities, and wanted to just maybe mention if the board can consider, or the commission can consider, maybe extending the annual Form 700 deadline for some of my filers and some of the filers that will be impacted because of the wildfires. Not only the filers that file through the county of Los Angeles, but maybe also the filers that file through individual cities, Malibu, Altadena, Pasadena, other areas that have been impacted by the fires. And I know it happened, and the commission during COVID extended the deadline, I believe, until July. Just wanted to drop that in the back of your thought processes to see if there's any possibility of doing that, because anything we can lessen the burden for some of these filers would be greatly appreciated. I would be one less thing for them to have to worry about doing for until the extended deadline, if possible. So those are my comments.
Thank you, Mr. Garcia. Again, our hearts go out to you and your staff and the officials and the people of Los Angeles. This is something that we can't take action on today. It's not agendized, but it's something we're going to consider what our options are. And of course, we'll keep you apprised of any developments. In addition to that, I just want to assure you and the public officials in the city and county of Los Angeles that we are going to surge resources towards your area in the form of trainings that are relevant to what you and your staff and your officials are going through, as well as materials. So keep an eye out for those. Something we take really seriously. We want to do everything we can do to support you and make sure you can comply with the rules. Is there anything else that commissioners wanted to touch on? Commissioner Baker?
Thank you for the comment, and I echo the chair's well wishes for you and everybody in Los Angeles County. I don't know if we can request this for a future agenda, but if it doesn't require an agenda and there's a precedent or other authority that either you as the full-time chair or commissioner may have, I would welcome seeing that happen. Whatever's expeditious and has precedent. I don't know if I'm getting into deliberation, but that's just my feedback. And if it does require becoming an agenda item, that we put this on the very next agenda, including if law and policy is the next committee to meet, or however we can expedite consideration of the matter. Thank you.
Can you speak to that? I believe that in the last circumstance, we had a regulation that allowed for this delay.
Yeah, so during, if everyone remembers, the stay-at-home order was March 19th, 2020, 11 days before the SEI April 1st deadline. So what the commission did in that instance was adopt an emergency regulation that extended the time period for filing an SEI. We set the time period, at least for 87-200 filers, by regulation. I believe for 87-300, it's set by their code, although typically their code is adopted using the standard language which we provide, which also is April 1st. So we can adopt a regulation that would extend the time if we chose to do that. We have done it before. There was obviously a lot less time between March 19th and April 1st and what we have in this instance. It wouldn't, if it was adopted, if the commission decided to do this, we could put it on an agenda for March for adoption and provide full notice through the OAL process, and it wouldn't need to be an emergency regulation in that standpoint. So it could be brought back in February for further discussion, but I think if the commission were intending to potentially go that direction, we would go ahead and notice a temporary regulation in advance of that discussion in February. If the commission decides not to do it, then we wouldn't have to adopt the regulation. But in order to notice it in time to be adopted at the March meeting before the April 1st deadline, we'd want to notice it in early February with OAL. And that is something that can be done at the chair's direction in between meetings that we prepare the paperwork to have it on the February or March agenda.
Yes, thank you, Council Bainbridge, for that outline. I would concur with the chair and vice chair that whatever we need to do to expedite this process, we should do so and cut through the red tape because a lot of people are, suffering in LA County. So thank you.
And this is something we can discuss at the end for the last item on the agenda for future agenda items.
Commissioner Wood has a statement.
Commissioner Wood?
Yeah, I just wanted to thank Mr. Garcia for commenting about this specifically. Sitting in LA County, it has been extremely disruptive down here. And then also, I appreciate Mr. Bainbridge explaining to us how we can kind of stick within the California, procedural requirements and still do this. So I'm hopeful that as listening to how all the commissioners, Commissioner Ortiz hasn't spoken yet, but seem really in support of extending this, that will help allow us to continue to do this kind of according to procedures, but also give people some confidence that it sounds like it's probably going to happen.
Of course, the March 3rd deadline for some Form 700 filers, is that right? And so would we be able to, unless I'm forgetting, I know it's on my calendar, or at least I got the notice from the FPPC that I have until March 3rd. So if there's an earlier deadline, local government, I think, is a month after state, certain filers. I'm not even going to pretend to know the full parameters of it. But if we just have that deadline as well in mind. And that's it.
Well, that's moving pieces when it comes to the Form 700, and especially potentially moving the deadline. So my thought is that we take this up on what would it be? Item number, item number 12, and then likely at that point move to agendize this for a future meeting, likely in February, so that we can have a decision by March. Excellent.
Can I just One more
Commissioner
thing,
Wood?
sorry. Just asking Mr. Bainbridge about this since he's the California procedural expert. If we were really push comes to shove for a March deadline, wouldn't we be able to adopt some kind of a direct regulation where we take comments after it? I know under the federal APA that kind of thing can happen.
I don't believe there's a similar process in California. There are available emergency regulations, but the standard for when something is an emergency is pretty high. So I'd have to look carefully at whether it would meet that criteria here. And 2.5 months out from the deadline, it might be hard to say if that even is an emergency in 2.5 months. So I think best approach would be to do it on the normal time through the normal process, which we do have time to do at this point.
Okay, sounds good. Thank you.
Thank you. Any additional public comment? No, seeing and hearing none, let's move on to item number 2, and that's going to be approval of our commission minutes. Commissioners, any suggested edits for the minutes? Commissioner Ortiz?
Thank you. Item number 12, I haven't been elevated to be a chair. I'm a commissioner. In case this Chair Ortiz asked. So I've corrected the commissioner.
Excellent
And now you're
catch
usurping
there.
your place.
I'm more than happy to be co-chairs with you, Commissioner Ortiz. Okay, any other suggested edits by commissioners? Okay, then I'm going to go ahead and move to adopt the minutes with that one change to item 12. Do I have a second?
Second.
Excellent. Do we have any public comment? Hearing and seeing none. Ms. Vo? Oh, it sounds like we do. Do we have public comment? Okay. Ms. Postle, you looked concerned. So, Ms. Vo, could you please take roll?
Commissioner Baker? Commissioner Ortiz?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Let's move on to the consent calendar. That's going to be items 3 through 5. Are there any items from the consent calendar that a commissioner wishes to remove? Commissioner Wilson?
Like to remove item number 4.
Okay, item number 4. Then why don't we go ahead and first consider the consent calendar, which is now going to be items 3 and 5. Do we have any public comment on the consent calendar items? Okay.
Move to approve the consent calendar.
Excellent. Do we have a second? Excellent. Ms. Vo?
Commissioner Baker?
Aye.
Commissioner Ortiz?
Aye.
Commissioner Wilson? Commissioner Wood?
Aye.
Chair Silver?
Aye.
Motion passes.
Okay, let's welcome our Chief Enforcement, James Lindsay, up to the table, and we'll touch on item number 4, and then subsequently we'll move on to items 6 and 7, our pre-notice default. Good morning, Mr. Lindsay.
Good morning, Mr. Chair and Commissioners. James Lindsay, Enforcement Chief.
Commissioner Wilson, as you pulled this item, I'll let you take it from here.
Yeah, I just want to say that the detailed outline and information on item 4 is very thorough and very clear. But I think for the benefit of the public, it would be good to outline how we came to the conclusion that the proposed penalty.
Sure, thank you for that. So this is a significant misuse of campaign funds matter that extended over a period of nearly 2 years. And quite a bit of money as well, roughly $15,000 was utilized for personal, certainly not political purposes, and for personal purposes as well, primarily gifts in the forms of various items to his close family members. And so we believed that this was a maximum penalty violation. Our process is typically that we definitely want to make sure that the fine is greater than the misuse. So we were able to, from a temporal standpoint and a type of expenditure standpoint, we were able to create 5 counts that we thought represented a fair penalty in this matter, and that's how we come to the $25,000 fine.
Kind of one follow-up question. I mean, it's outlined in all of the excellent detail in the materials that were submitted to the commission and to the public. But it's, from what I recall, is that the elected official involved had extensive experience as elected official, and I think it was back to, he was elected in the year 2000. Is that correct?
Yeah, actually, even it goes back to 1997. He was on the Salinas City Council, I believe, from 1997 to 2000, and then spent 16 years on the Monterey County Board of Supervisors. So yes, roughly a 20-year public service career.
Anyway, the key question that I have is the fine paid through personal funds, or can it be paid with campaign funds?
Personal use is paid through personal funds, and there were no campaign funds left because they were essentially exhausted through the misuse. You're welcome. You're welcome.
And just to clarify, with the types of violations that are being prosecuted here, you cannot pay the fine with campaign funds, correct?
Yes, that is my understanding.
Okay, excellent. Commissioner Ortiz?
Okay. On page 7, you talked about personal benefit. And so I assume that the personal benefit is conferred to the person who is violating and making the questionable payments. But then it was also money given to an adult child and a grandchildren. So they don't, even though they are related, they don't become part of the personal benefit?
Yeah, and in addition, there were expenditures, reimbursements for things that they had already personally taken, expended their own personal.
So if one of those children or grandchildren lived with them, with Armentos, would that have been a violation if, I mean, would that be part of the personal benefit? If a kid lived in the house?
Yes.
Okay. And that would have been actionable?
Yes.
Yeah, okay, thank you.
Thank you, Commissioner Wilson, for pulling this. It is an opportunity to say thank you for the maximum penalty for personal use. It was good to see. I just completely agree. And I'm glad that it's in proportion to what the individual did. I do note that on page 7, this is one of the few instances where a respondent says they did consult the FPPC. I note at the bottom, it's lines 23 to about 26, where it's mentioned that it wasn't clear that advice might have been provided. I'm sure these particular points in language are individually negotiated potentially, but if ever, we don't have record, as I understand sometimes, unless they emailed us. If somebody called by phone, from prior reports, I understand we don't keep a log of phone calls, but if we have an email or a more formal request, we do. And if in stipulations it's ever possible to note, there was no record of them doing it. That was the one thing that I was like, I wonder if there was just no record, or if this person said they couldn't remember when it was. It doesn't come up often that somebody at least claims or says that they did contact us for advice. That's a very gentle point of feedback, but really a gratitude that this is the maximum penalty for each of the counts, because we've prioritized these cases throughout the years.
Okay.
Thank you.
Thank you very much. And yes, we wouldn't normally. I think the clause, although it is unclear when the advice may have been provided, was kind of our way of saying we couldn't verify that this occurred without saying that it didn't. Yeah.
Let you put that in the negotiated stipulation. Thank you.
Any additional commissioner comment on this item? Okay, do we have any public comment? Okay, hearing and seeing none. I'm going to go ahead and move to approve item number 4. Have a second? Second. Excellent. Ms. Vo?
Commissioner Baker, Commissioner Ortiz, Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Silver.
Aye.
Motion passes.
Let's move on to our pre-notice defaults, items 6 and 7. Any information you'd like to share on these, Mr. Lindsay?
Yeah, no additional information. Again, just to remind everybody in the public that we put these on for pre-notice, not because there's a specific requirement to do so, but it's to, again, make some sort of effort to get the attention of the individuals. And we have not received at this point any communication on these particular matters.
Thank you. Okay, no action needs to be taken on 6 or 7 as they're pre-notice defaults. So do we have any comments from commissioners? No? Any public comment on this item? Hearing and seeing none, why don't we move on to item 8? That's going to be a pre-notice discussion of proposed repeal and amendment of the Levine Act, Section 84308 regulations and related regulations, 18360.1, 18438.2 through 18438.8, and 18705. I'm welcoming to the table here Senior Commission Counsel Kevin Cornwall. Good morning, Mr. Cornwall, and I believe remotely we have Commission Counsel Torrin Lewis. Good morning, Mr. Lewis.
Good morning. So good morning, Mr. Chairman and Commissioners. Again, my name is Torrin Lewis, Commission Counsel with the Legal Division, here with my colleague Kevin Cornwall, Senior Commission Counsel with the Legal Division as well. Both of us, as noted, are going to be discussing pre-notice discussion of a regulation package related to some legislative changes that were recently enacted and went into effect on the 1st of this year, pertaining to Section 84308 of the Act, also commonly known as the Levine Act. In addition to some regulatory changes pertaining to those statutory updates that were recently made, we have some additional clarification and cleanup to the related regulations that we're going to be sharing with you as well, based on some recent advice in this same area of law. So I'll begin remotely with a quick overview of the Levine Act, as well as a quick summary of the recent legislative changes. And then Kevin and I will alternate summarizing our proposed regulatory changes in response to the recent statutory amendments. And please, of course, feel free to interrupt with questions at any point, and we'll pause for questions as well. So for starters, what is the Levine Act? Again, this is found in Section 84308 of the Political Reform Act. It's aimed at combating so-called pay-to-play or quid pro quo practices and their appearance. It was originally enacted in 1982 by the state legislature following a report in the Los Angeles Times about several state coastal commissioners who had solicited large campaign contributions and received those large campaign contributions from persons who were appearing before them regarding applications pending before the Coastal Commission. So what does this law do? It has 3 basic components. The first is what we could call the contribution limit component. And this provides that while a proceeding is pending, an officer of an agency cannot accept, solicit, or direct contributions exceeding the limit, which is now $500, but was formerly $250, which we'll address, from parties and their agents or participants and their agents, if that officer knows or has reason to know that the participant has a financial interest. This $500, again, formerly $250 limit, applies for any 12-month period while the proceeding is pending, and for 12 months thereafter, after, I should say, a final decision is rendered. The next prong of the Levine Act is the recusal requirement, which provides that if an officer has received such a contribution in the preceding 12 months, they have to recuse themselves from the proceeding And finally, there's a disclosure requirement which provides that such an officer who must recuse themselves must also disclose this fact on the record. Now, in 2023, some previous legislation went into effect that broadened the scope of the Levine Act at that time. Previously, it applied only to appointed members of commissions and boards. So in 2023, as of 2023, it also applied to local elected officials as well. And then this year, as mentioned, additional legislation went into effect, which made several significant changes to the Levine Act. And these include raising the contribution threshold, as I intimated, from $250 to $500, defining certain key terms, such as when something is pending before an official, who is an agent, what constitutes a license, permit, or other entitlement for use, and for that matter, what does not, and then what type of contract decisions fall under the purview of 84308, as well as specifying that contributions from agents are now no longer aggregated with those of parties. Two more things the new legislative changes do that we'll get into in more detail. They expand the circumstances in which a disqualifying contribution may be returned, and they extend the time period for return. And likewise for the disclosure time period, if they clarify that the time period during which a party to an entitlement for use proceeding must disclose that it made a contribution greater than the threshold, so that there's just some clarification of when that needs to happen. And so those are the most recent legislative updates. Aside from those, one additional reason for our proposed amendments are that, separate from these changes, some recent advice requests have highlighted some other issues in this area of the Act that we think could benefit from clarification by regulation. And Kevin and I will highlight these as they come up. With that, I'll pause before launching into our actual proposed regulatory amendments to see if there are any questions.
Commissioner Baker?
Thank you. I have a question about looking at page 4 of the staff memo at the top, the business/nonprofit participant materiality standard, regulation 18438.4. Is that one of the recommendations for change that you're presenting that's based on the recent amendments in statute, or based on the experience that your legal division has had in providing advice?
Yeah, this is not based on the recent amendments. This is basically just a point of clarification, essentially putting into regulation what we have previously advised in past advice letters, both recently and prior to even the 2023 amendments.
Okay. If that would be one provision that I hope there's robust outreach and engagement to determine that if that is appropriate, and I hope that we'll get comment that's robust on that, because it isn't what's necessarily in the statute that was recently amended, which means in my mind, if the legislature wanted to change it, they would have, and they're well aware of, or should be well aware of, what advice letters are. But I think it's a significant and material provision to say that a whole segment, I wouldn't say a whole segment, but that the definition of participant doesn't cover certain nonprofits, including labor, for purposes of complying with the Act. So I don't know what outreach you do, or I know if this will qualify for an interested person's notification, or just the standard, we have a process of pre-notice and final adoption. But to the world that's out there, I hope they are just giving this close attention.
Yeah, I mean, I can get into it now, or as we go along, whichever you prefer.
Well, where do you think it fits in, or the chair would like it addressed?
I think since the issue has already been raised, and that's part of one of the amendments, why don't we address that now and you can circle back to the rest of the
Sure. Yeah.
Before we do, I know Commissioner Reed has a
Oh,
question.
yeah.
Did that
No.
relate to this specific amendment?
No, similar but not to that specific.
Okay, why don't we do this? Why don't we touch on this first and then we'll circle
Okay.
back to you, Commissioner? Excellent.
From that particular regulation. Okay. Yeah, so Regulation 18438.4, that regulation expands on the term participant in the context of Section 84308, which is essentially it's a person, including a business entity or nonprofit, who has a financial interest in the proceeding and is acting to influence the proceeding, but they don't qualify as a party as they're not the subject of the proceeding. This proposed amendment would clarify the applicable standards when determining whether a business entity or nonprofit has a financial interest in the proceeding. So Section 84308 states that the conflict of interest standards are to be applied in determining whether a participant has a financial interest. But those standards generally apply to individuals rather than entities. So our regulation 18702.3 has the standards that we apply in determining the materiality of a financial effect on nonprofits and business entities. And this amendment would clarify their applicability and help direct the regulated community to the relevant standards. I think part of it is just clarifying where to find the applicable standards, because typically, like I said, when we're looking at a conflict, we're generally looking at an individual. And so looking at the regulation for source of income, it might not be immediately obvious that that regulation contains the standards that we have historically used in determining the materiality of a financial effect on those types of entities.
Commissioner Baker?
Thank you. I appreciate that. And given, I guess the practical implication, first of all, is that there's going to be more clarification. Have you had what kind of volume of questions about this have you had? I know you cited 2 advice letters in the staff memo. How much is there been a lack of clarity on this? That's my first question.
Yeah, I mean, I think that's reflective of the frequency with which it comes up. It's a pretty infrequent topic. And I'm not sure if you would remember that I think in June 2023, when we adopted the initial regulations, we had a lot of concern.
Yeah.
I think we had like 12, people calling in, basically voicing concern about how the term participant would apply to labor unions. And I think that a lot of that was sort of just sort of initial uneasiness about the changes to 84308 in general, because a lot of the concerns that were raised were things that I think in practice and that we see now with a little bit more time, essentially it's hard to imagine a scenario in which that type of organization or a business entity or the circumstances that were raised specifically in those calls dealt with like membership dues and that sort of thing, creating a financial interest that would qualify a labor union as a participant. It's fairly unlikely for that type of situation to arise. I believe in that circumstance, we had callers requesting essentially language to the effect of if that a labor union would not qualify as a participant based on like additional hours or additional wages that its members obtained as a result of a proceeding. We didn't adopt any sort of language to that effect at the time. But with the most recent amendment to Section 84308, it seems like that was sort of addressed statutorily in the amended definition of participant, which you'll now notice specifies that an increase in membership dues doesn't result in someone qualifying as, or an organization qualifying as a participant.
Well, that experience in the hearing where we did have quite a few public comment was why this one sort of popped out at mind for me. As I was thinking, this was the issue that folks had come to us and spoken. And at the time I felt there was a little bit of, well, you know, this has been out there and it's kind of on the eve of adoption, excuse me, that you're raising this. And we felt that the language was fine. And so, you know, where I'm going with this is during this pre-notice period, to me, it is a significant issue if there are organizations that have major contracts, including employment contracts with an entity, if they are going to be, I don't want to say exempt, but if they're through a definition, are those contributions that they may make to the deciders of the contract are not considered within the Levine Act. And because that is significant, even if it doesn't come up often, that is different than if membership dues alone make you a participant.
Right.
Can you address that? Because I feel like that's a bigger issue than what's maybe I picked up on from the staff memo.
I think that's somewhat of a separate issue because I think that in the situations where we're dealing with contracts between a union and the government agency, then in those instances the union or whatever the entity is going to qualify as a party and fall within the scope of 84308. There are certain statutory exceptions, outside of the regs that were or regulatory amendments that we're proposing here, but there are statutory exceptions for certain types of contracts, including certain employment contracts. So those would fall outside of 84308. But part of why I was saying the difficulty in coming up with a scenario in which these fears seem sort of founded is that as a participant, you're sort of somewhat removed from the proceeding. You're not a party to it. So finding that this proceeding would have sort of an indirect financial effect on a labor union, especially when it's, the concern is based on, I guess, increased membership dues or that sort of thing. It's hard to imagine a situation in which you can say that, this proceeding is the direct cause of this increase or decrease in membership dues. So I think it's hard to conceivably establish a financial interest on that basis.
Yeah, that is more attenuated for me. So I'm imagining a situation where maybe there's a labor contract that's before a body and 50 members of that, I should pick a business association. I'm just trying to, labor's been more mentioned here, so, and it's a little bit more of a concrete example, but in fairness, that should apply to any association.
Or nonprofit. Yeah.
Or nonprofit, thank you. But and then maybe 50 members of that organization who pay dues to the entity are coming and giving public comment, and that entity has made a political contribution to people on the board.
Mm-hmm.
So is the practical impact of what's proposed here that those 50 people who are in line making comment, just because they're members of the labor union, they're not considered individual participants or party, even though the labor union is, and their contract, which will affect the livelihoods of those individuals, is before the body, and they made contributions. I'm trying to figure out how this affects the scenario that's very real, which is 50 people line up and comment and say, hey, I want you to approve this contract.
So in the scenario you're describing, it would be the labor union is a party to the proceeding, and the members are essentially participating, lining up and providing comment? Or,
yes.
Okay, so in those situations, you would look at whether the individual would experience, or the individual would have a financial interest in the proceeding. But again, it would be a situation that would be hard to, I guess I'm trying to think of a scenario in which an individual, we would look at, whether they have, whether their source of income would experience a material financial effect. And in those instances, that person could qualify as a participant in
Okay.
that context, yeah.
Okay. Under the proposal that's here, they could still qualify as a participant.
Yes,
Okay.
yeah, individual members, yes.
Gotcha.
Yeah,
That-
and I
that's
mean,
helpful.
and conceivably, you know, if like someone acting as a representative of a union in a different type of proceeding, they could also qualify, but.
And, oh, please, yeah, and it's regardless of whether their dues increase or decrease from the decision.
Yeah, I would have to look at the updated language for 84308 again. I believe that the language in 84308 specifically relating to increases or decreases speaks to the organization.
Gotcha.
Whereas I don't know that it speaks to essentially the personal financial effect it would have on an individual member.
Thank you. And I do remember the first time the bill was passed, before these amendments, a lot of this was carved out and provided for in the statute. I'm just making sure where we're going with the proposed regulations.
And I'm
I'm good,
Chair,
but I
so-
thank you, Mr. Chair. You were very kind to let me keep going after you asked.
Of course, I appreciate you asking all these questions because as someone who watched the implementation of the regulations last time around, I feel like perhaps we could have raised more issues to get more public comment from stakeholders so that we could have addressed some of the problems that came up after regulations were
Right.
adopted. So I'm glad we're flushing all of this out at this point. And I really, like Commissioner Baker pointed out, I really encourage the regulated community to engage on this. We need your feedback, so please provide us with comment. This is on pre-notice. We're not taking action today, so we'd really appreciate that. Great. Just one clarifying item on this, since we're just talking about the amendments to 18438.4.
Right.
So basically what we're doing here is we're providing a path. We're making it clear to the regulated community, this is how you do this analysis.
Right.
Right? And we do that in several different places in the conflict of interest context, right? Because
Yes.
these rules can be very difficult for public officials to navigate, even difficult for their legal advisors to navigate. So what we're doing here is we're telling them, not specifically as to labor organizations, but if there's a business entity or nonprofit, if you want to consider whether there's a financial interest or that they have a financial interest, you should go look at regulation 18702.3 and then
Right.
consider whether you meet one of those thresholds. And what
Yeah.
you were saying as to labor unions is that it's difficult to conceive of a situation where one of those thresholds would be met as to a nonprofit labor union, right? It's not as if there's an exception here.
Right.
We're telling the public officials attempting to comply with this, stakeholders attempting to comply with this rule, that to confirm that you do not or do have a financial interest, go look at this other regulation at the different thresholds in it.
Right, because these standards deal with certain monetary thresholds, like $1 million and 5%, or $1 million or 5% and X amount of money. When you're talking about a more attenuated situation, where you're not participating as a party, but as a participant, it's a little bit more difficult to see, for a public official to make that determination that this entitlement for use proceeding is what's going to lead to, $1 million increase or decrease in the net receipts of a labor union. But like you said, I think that this is more just pointing people in the right direction. Again, with the conflict of interest standards, which 84308 directs us to apply in determining whether someone qualifies as a participant, those are typically going to be applied to individuals because they're drafted with respect to determining whether a public official has a conflict of interest. So here, we're sort of directing them to these specific standards to avoid the situation of like, oh, well, so how do I determine who's a source of gifts, to this labor union? That's not what we're looking at. We're looking at the bigger picture in terms of the overall financial effect that it'll have on these types of entities.
Commissioner Wood?
I feel like the moment has slightly passed, but I also just want to make sure we clarify for the record. If I'm right, I've got 84308 pulled up, and 5B2 says that license, permit, or other entitlement for use does not include labor contracts. And so if a labor contract is actually in front of a commission, that is actually exempted from this whole thing anyway. And so I just wanted to make sure that that was out there, like in the minutes of this meeting, because I think the example that was given was a labor contract. And so I think instead it would be, I feel like last time we did this, we talked about plumbers unions or electrical unions or something. But if there's a contract that's going to happen for the city and, you know, some developer tends to work with these certain unions, then the real question becomes whether, if members from those unions urge them to adopt the contract, is that a Levine Act violation? Am I right about that part?
Yeah. So
Not a Levine, I'm sorry, not a Levine Act violation, but that if it doesn't end up getting disclosed or something, it would be a Levine Act violation. I just want to make sure I'm clear on like the kind of factual situation we're talking about that
Right.
actually is relevant to unions.
Yeah, so I think a good example of this is, and I forget, we had two similar advice letters that we cited in the memo, Dave Bartnowski and Sablin. Both of them kind of demonstrated how we do this type of analysis with respect to unions. But one of the letters pointed out that, you know, while a labor union contract is exempt, the contract at issue in that particular letter was a contract for services that fell outside of that context. And so you did have a situation where, you know, members of the union were participating as potential participants. And so that was the context in which we were analyzing, you know, whether the union or its members were qualifying as participants, but not with respect to actual labor contracts that meet that specific definition.
So in both of those examples, there was no need for disclosure. And so then I wonder if Commissioner Baker, how she feels about that, right? Like if there should have been a disclosure in that kind of context. I just want to make sure we're really clear on what the concern is, because we want to make sure that if we're going to not solicit comment, but like, you know, encourage the public to kind of come forward and let us know what they think about this, that we're really precise on what it is where the kind of confusion or question is.
And I think that sort of highlights one of the other sort of quirks of 84308, in that parties are required to disclose those contributions, but participants are not statutorily required to disclose those contributions. So again, with respect to whether a public official would need to disclose anything, generally is going to depend on the amount of information that is disclosed to them by the participant, or what they know or should know, you know, which we address in our regulations.
Would for trying to help me get things more clear what my concerns are. The first one was that how much we were, and I think the chair actually clarified this very well. Thank you, I appreciate it. How much was this by what is in the statute, and we're just updating the regs, this particular provision, and how much is based on feedback and public comment that we received previously in the experience of the legal division? I think that's been answered. My second was, and I referenced that when the original statute was passed, some of this was already dealt with, including the labor contracts provision that was just read. For me, it is how, if this isn't in statute specifically, and we are essentially codifying advice letters on here's how you're going to do this analysis, how that might, I use the word exempt employees who could have an interest in the outcome of you identified a services agreement example. Labor contracts was not a great one for my part. How that could exempt them from either the elected official or who the participant is from the purpose of the pay-to-play statute, which is if you're giving money to the people who are deciding something you could have an interest in, there's restrictions and there's rules. And I wanted to make sure that we weren't basically changing what is the purpose of the original statute, both based on the public comment that we received kind of late last time and without real clarity that that's what we should be doing. And that's where I was going with this. And I think because this is pre-notice, there's going to be more conversations about it, but that's my interest. I probably shouldn't have given a labor contract example. Maybe I should have stuck with the business association, or you gave a better services contract example.
So I don't know that I would characterize it as codifying past advice letters. I think that we are clarifying the applicable standard in that the statute does direct us to use the 87-100 conflict standards. The act itself doesn't really include any of those standards. Those are all included in our regulations, which is 18702.1 through 5. And so each of those deals with, okay, when a public official has an interest in a business entity or real property or a source of income or a source of gifts or their personal finances. And each of those deals with, the financial impact on the individual's various interests. But because they're not drafted in the context of, an entity and determining the conflict that the financial impact that it might have on an entity, these are the standards that we have within those dealing with nonprofit entities and business entities that are the most applicable. And so we're essentially just directing people there. Yeah.
Yes. Thank you, Ms. Cornwall. I appreciate all the detailed material that you provided us. But under 84308, as Commissioner Baker mentioned, labor contracts, do not apply under this particular statute. But there's also contracts valued under $50,000. What other examples would fall within the exceptions that are outlined in the statute?
I'm sorry, could examples of?
Well, it says a license, permit, or other entitlement or use does not include any of the following. It mentions labor contracts, personal employment contracts. So am I reading the right code section?
Yeah,
right.
And this is the recently amended aspect of 84308, which added that exception for contracts valued under $50,000.
So if someone appeared before city council and there was a contract that was $40,000,
right,
then this particular statute would not apply to them, correct?
Correct.
Okay. Yeah, I think it's important to emphasize it, and Commissioner Baker touched on it, that there are some exceptions that fall outside of the purview of this particular statute. Okay. Thank you.
Yeah, thank you. I have been trying to understand why central committees were included in this. Is this by legislation that we're abiding or what? I mean, and how are they impacted? I know that some central committees are raising a lot of money to be elected, but I'm trying to, and what I recall, all they do is support candidates or support ballot measures and things like that. So how are they impacted by this?
Well, it's going to apply to the individual that's running to be on the central committee. And so 84308 applies not only to elected officials, but candidates running for office. And it also applies to, and the act defines elective office. I believe it expressly includes central committees in its definition of elective office.
Elected office, yeah.
So,
but how will this member of the central committee violate this? How? So if that's not part, they don't go approving contracts before an agency or anything.
Right. So I think historically with the act, as Torrin mentioned with the LA Times article and the central California Coastal Committee, the situations that you have are situations where a public official is a member of one board and they're running for some other type of office, and they receive a contribution for that candidacy while acting in their capacity on this other board. And so in that situation, you had members of the California Coastal Commission who I believe were running for like LA City Council. And so it's just saying it's us, or it's the act, sorry. Section 84308 is basically saying you can't accept a contribution of $1,000 to your bid for being a member of the central committee, and then in this other capacity, make a decision affecting the person that just contributed that money to you.
And that's what I'm trying to figure out. I mean, because the central committees, all they do, endorse candidates and things like that. They don't get involved in contracts like the Coastal Commission will be involved in contracts. And so this will be interesting. The Central Committee members don't know about, I don't think they know about stuff like this. So it will be good to have some education or some sort of training or something. But I don't see how they're going to violate it.
Can I
chime in? Oh.
Yeah, sure. Whatever.
Somebody talk. Council Lewis, just one moment. I'm going to throw this over to General Counsel Bainbridge. It's my understanding that the issue here is we're trying to determine whether central committees, whether candidates for central committees are going to be considered candidates for elective office for purposes of 84308. So we're not looking at the decisions before the central committee.
Yeah.
We're looking at the decisions that candidates for a central committee are making in their official capacity as public officials, similarly to a candidate for city council.
So not once they're been elected. Is that what you're saying? To the central committee?
Well, I'll go ahead and let the expert explain it.
Let me give a concrete scenario that I think will help you understand. You have a person running for, or on the city council, let's say. They also are running for the county central committee position. They can't, and let's say a developer, always pick on developers, comes before the city council and has a decision for a development. That developer can't make a contribution of over $500 to the central committee that this person has
Got it.
that's on the city council.
Got it. Now it makes sense because I kept reading and reading. I'm trying to figure out a situation where a member of the central committee will be violating it because they don't, sorry.
Yeah, it's not decisions by the central committee, it's
Yeah.
decisions by the other
Okay,
position.
so that situation where you're already an elected official and running, which I think is happening more and more. Okay, thank you, appreciate it.
Okay, great. I think something that'll be really important for the regulated community as they bring comment on this, for us to clarify what is just reflective of what's in the statute, which is most of this, and then what is to an extent up to our discretion, right? So I don't know, at this point, I assume you're going to run through each one of these amended regulations that we're proposing. Perhaps at the end, you just lay that out and make it clear. So I'll leave it up to you to move on. I don't know which one of the amended regulations you want to start with, but go ahead, Mr. Cornwall.
Torrin, I'll throw it back to you.
Sure. If the commissioners would like, I thought it might be helpful to just start out of order with the one we were just talking about, since it's on top of everyone's mind. And that would be the proposed changes to Regulation 18438.6. And so to the commissioners' questions, I think my colleague Kevin mentioned that this change relates to some previous advice that staff has provided. But to be very clear, this is not some kind of extrapolation. This is simply the application of existing definitions. So if I could point everyone to section 84308A4 of the Act that defines officer, and that definition includes any candidate for elective office. And so now section 82023 defines elective office to include membership on a county central committee. So that's all we're doing here is really clarifying application of existing law. It happens to be the subject of a 2023 advice letter, but it's not some kind of, it's not a novel issue whatsoever. So that's that issue, 18438.6. Any further questions on that before I'll go backwards to 18438.2?
Any insight you can share with us as to why that specific type of candidate wasn't initially included in 18438.6?
That is a great question. I personally do not have any insight on that.
Okay, I think it'd be helpful if there is any legislative history in general that we could look into and identify related to that. It'd be helpful to have that for adoption. Go ahead. Mr. Lewis, unless any commissioners have any questions on that one. Okay, go ahead.
Okay, so backing up, the first proposed regulatory change is to existing regulation 18438.2. This concerns proceedings under 84308. And prior to the most recent legislative changes, subdivision A of section 84308 defined most of the key terms in the statute. The recent changes have made some amendments and clarifications to those key changes, including some that the commission and staff were just discussing a moment ago, such as that labor contracts are now expressly defined as not being licensed, permanent, other entitlement for use proceedings, as well as contracts valued under $50,000 and so forth. So those are some recent legislative changes that necessitate essentially just some strikeouts of definitions that existed in 18438.2 because they were not laid out in statute. And so they required further clarification prior to the recent legislation. Notably, newly enacted paragraph 7 of 84308A now defines when an entitlement for use proceeding is pending, and therefore that definition must also be removed from 18438.2 since that was later in regulation, but it's now in statute. I think those are the main changes to that regulation, unless there's any further questions on that one. Okay. So next, we recommend some amendments to existing regulation 18438.3. This regulation concerns agents under section 84308. Prior to the recent statutory changes, the Act was actually silent on the definition of agent. Therefore, regulation 18438 was actually devoted to defining this term. But now the term agent for purposes of 84308 is defined in newly enacted subdivision H of section 84308 of the Act. So because this has been codified in statute, staff is recommending repeal of this entire regulation because it is no longer necessary. With that, I'll pause for any questions and otherwise turn it over to Kevin for the next reg.
Okay, so got quite a bit of discussion in on 18438.4 already, but just to reiterate, our proposed amendment, our regulation 18702.3 has standards for determining the materiality of a financial effect on nonprofits and business entities. And so this amendment would clarify their applicability and help direct the regulated community to the relevant standards. And again, this isn't necessitated by the most recent amendments to section 84308, just a bit of clarification based on questions we occasionally receive. more.
Yeah, the only question that I have on that one at this point is, can you shed some light on why we decided to go with 18702.3 rather than one of the other materiality standards for that analysis?
Yeah, so 18702.3 is the regulation that deals with determining the materiality of a financial effect on an individual's source of income. And so within that regulation, we have broad standards for determining when a financial impact on a business entity or a nonprofit entity are materially affected by a decision. I should clarify that 18702.3 with respect to business entities, it cites back to 18702.1, which deals with business entities. But essentially, they both include the same substantive standards. One, I think, is just phrased with regard to annual revenue, and the other is nonprofits is phrased with annual receipts. But these are the sort of broader standards for determining the overall material financial effect on one of these entities. In that context.
That's helpful. Thank you. Any other questions on that, commissioners? Great. Go ahead.
And so for regulation 18438.5, this regulation deals with how contributions are aggregated when dealing with multiple contributions from related sources. So if you have, for example, a contribution made by two individuals who are co-owners of the business that has a matter before the city council, you're going to aggregate the contributions from both of those in determining whether it's exceeded the permissible amount. So based on amendments to section 84308, which now specifies that contributions by agents are not aggregated with contributions by parties or participants, we have amended the regulation to that effect. So if there are any questions about that. Okay. And then I'll throw back to Torrin for point 6.
Thank you. So again, regulation 18438.6 regarding county central committees, candidates for those being under the purview of section 84308. I think we've discussed that at length, but happy to answer any further questions on that one if there are any.
Yeah, I think we're ready to move on to point 7.
So this regulation broadly addresses prohibitions and disqualification under section 84308. Section 84308D allows a public official who received a disqualifying contribution to participate in an entitlement for use proceeding if the official returns the contribution within 30 days from the time the officer makes any decision or knows or should have known about the contribution and the proceeding, whichever comes last. So with parties no longer required to immediately disclose contributions upon initiating an entitlement for use proceeding, which we'll talk about later, it's become more necessary to clarify the circumstances in which a public official knew or should have known about a contribution. So we've done so here by tying the terms into into 18438.7b, which provides standards for the substantively similar phrase willfully or knowingly received a contribution. So if there are any questions related to this. Okay. And then with regulation 18438.8, this regulation deals with disclosure requirements under section 84308, both for the public official and for parties. As I just mentioned, section 84308 was amended so that rather than requiring disclosure by parties of contributions made within the preceding 12 months, which was the previous language, it now specifies that disclosure is required for contributions made within the preceding 12 months before the date that any decision is rendered by the agency. So whereas our regulation previously required disclosure upon initiating a proceeding, we understand this amendment, this statutory amendment, to establish a more lenient timeline for disclosure by parties. So our proposed language is requiring disclosure at least 30 days before the date that any decision is rendered by the agency, which allows the party to make disclosure after the point of initiating a proceeding, but still allows time for review of the disclosure by members of the public, as well as the public official who might be impacted or whose participation might be impacted by that disclosure. And then just one further thing, staff intends to further amend this proposed language just to clarify essentially something to the effect of at least 30 days before the date or at the time of initiating the proceeding, just to address the, I guess, I'm not sure if this would be probably a rare instance in which a decision is made by an agency within 30 days, just so that they're not, technically violating that rule. But if there are any questions related to that, I'd be happy to answer them. Okay, and then I will throw back to Torin.
All right, thank you, Kevin. So the next regulation staff proposes making amendments to is existing regulation 18360.1. This regulation concerns the eligibility requirements for our streamlined program, aka streamlined program warning letters and PrEP. So as I think I mentioned at the top of the presentation, the recent amendments to Section 84308 have raised the contribution threshold from $250 to $500. And so for this reason, staff's recommending a number of amendments to 18360.1 subdivision E 12 in particular to reflect that dollar amount change. And then if there are no questions about that, finally.
So sorry to interrupt you, Mr. Lewis. I'd have more of a comment on that one. Or I guess a question. Is this one of the few areas or only area where we do streamline for conflicts? Is that correct? Executive Director West?
That's correct. We also do it for recusal. If you didn't properly recuse yourself, then you could qualify for the streamline program as well.
Okay. Personally, I feel that conflict of interest violations are some of the most egregious violations of the Act, greatest public harm. So I'd be interested to hear what the other commissioners, what stakeholders, et cetera, feel about having a conflict of interest provision within the streamline regulations. I don't know if this was something that was discussed when we adopted streamline regulations several years ago, but this is something that's of interest to me and that perhaps we can talk about now, when we're adopting the regulations at our, I believe, our March meeting. Any commissioner comment on that item? Commissioner
Just to clarify, so is your point that the discussion of the existing rule for 84308 or making additions or subtractions from it? I'm unclear.
Yeah, thank you for seeking that clarification. What I'm looking for is consideration of whether this is an appropriate violation to have under the streamline regulations. And then if it is, where we want to place the thresholds for allowing this under streamline. It looks like we're basically just reflecting the statutory change in the streamlined regulations, right? Raising 250, which previously was the contribution threshold for potentially triggering 84308 violation, to now 500. My question is whether we want to take additional action, either to make the availability of streamline stricter in terms of 84308 or just remove it from streamline regulations.
Yeah, That's a great point. The legal division had planned to reach out to enforcement after this meeting in order to talk about those thresholds and what's been working or what they've seen in their cases in order to make recommendations at the next hearing.
Excellent. That's helpful.
Yeah, and,
Mr. Wilson?
and I think in the course of, making that assessment, because 84308 violations are serious, I personally would have to be strongly convinced that they would be eligible for the streamlining. I mean, but I'll wait to hear what the experts come up with.
Yeah, I think what would be helpful is for us to go through a couple of scenarios that would qualify under the Streamline program so that the commission could understand sometimes the technical nature of following 84308 rules as opposed to the conflict portion of the 84308 rules. Because there are a lot of disclosure and timelines that are included in there, which is what Streamline is trying to encompass, as opposed to the actual making a decision benefiting yourself. So we'd be happy to discuss that further.
Commissioner Baker?
Thank you. In response to your question, I agree with also Commissioner Wilson. This is appropriate for discussion to be considered at all to be in Streamline. But I was originally going to ask a question too, and that is the example Director West gave was recusal, failure to recuse. And I imagine there's more to that because failure to recuse could be a pretty serious point that perhaps none of us would want to see in Streamline. Were you indicating maybe they used the wrong words or they did it not quite technically correct, as opposed to they didn't recuse? I think because the example you gave is here's what might qualify for Streamline sort of perked my ear like, good grief, I don't know that I'd want somebody who didn't recuse or failed to. I'm sure that is not the fact scenario you were thinking.
No, it is not. All good questions, and maybe a refresher on Streamline next year might be a great way to go. But when we added the proper recusal, which is the term for it, is whether or not the recusal was done exactly correctly, as opposed to did they recuse or not recuse? Because our recusal rules are very strict and formal as to you have to leave the room, you have to declare certain things, and you have to do them in a certain time frame. So again, Streamline has we've identified for Streamline a lot of the rules that have deadlines, certain exact disclosures, certain exact statements, the things that the commission has determined in the past to not want to spend extra time on. So things for enforcement to be able to streamline out as opposed to the things where someone didn't recuse at all, went ahead and made a decision knowing that they had a conflict, all of the things with intent that have been included still in the mainline processes.
Thank you. And then to the chair's more direct question, I would be very open to us evaluating what, if any, of a violation of this provision would qualify. And if we, as a commission, were to determine some can, that we are very clear on what does and does not, so it's memorialized as much as possible and not determined, it isn't something that gets forgotten or, which I'm sure the team wouldn't do here. And if there's discretion that is left with, say, the director or the enforcement division, that we provide very clear parameters on what that discretion is, so that there's no lack of clarity. Thank you.
Great points. Okay. Mr. Lewis, anything additional on that regulation, that proposed amended regulation?
Not on that one.
Okay, I think we can move on to the last amended regulation.
Certainly. So relatedly, on the last regulation, we propose amending, which is 18705 regarding the rules for legally required participation. So this reg sets forth standards where an otherwise disqualified official is still permitted to take part in a decision because their participation is legally required, as the rule is named. So again, this regulation, just for context, was amended in 2023 to encompass disqualifications under 84308. And we're just proposing a very minor change on, let's see, it's in 18705 B1B, and so that's on the second page of the reg, just crossing out the $250 and updating it to the $500 threshold. But yeah, if the commission has any questions or discussion about this, happy to. I'm all ears.
I don't see any. Now that we've gotten through all the amended regulations, congratulations to you both. How about, if you wouldn't mind, running through what you feel are items that are essentially up to our, in a sense, up to our discretion versus those that are just reflective of the statute. And while we accept or would want any sort of comment from the regulated community, I think it's most helpful to get comment on those sorts of proposals that are up to our discretion versus just reflective of the statute.
Sure. So I can start off the top. So 18438.2, again, just deleting what are now extraneous terms that are defined in statute, which previously needed to be defined in reg, is not really up to our discretion. And some of those terms are now, for example, pending is now defined in statute. We're just literally crossing that out. The second portion that we discussed about clarifying when a proceeding initiated by an agency also qualifies as a entitlement for use proceeding under 84308. That is a separate issue from the recent statutory changes, so that's up to the commission's discretion.
And that's also, just to clarify, that's an 18438.2?
Correct.
Okay.
Right.
Thank you.
On 18438.3, where we recommend its repeal, I think this is really, there's no discretion involved there. That's just a term that's now defined in statute.
Thank you.
For regulation 18438.4, I guess there's elements of both. The section 84308 does require us to apply the conflict of interest standards under 87-100. However, those standards are essentially expanded on in our regulations where we establish the actual standards. So theoretically, the commission, if they wanted to establish a different standard for determining, materiality in this context, they could do that. But I think that this is an appropriate standard. It's consistent with how we've historically treated these scenarios. So, I think primarily it's coming from the statutory requirement.
That's helpful. Thank you.
For regulation 18438.5, we've just removed references to agents, given that the statute now requires that we not aggregate contributions by agents with contributions by parties or participants. That's in part because agents are prohibited from making contributions while the proceeding is pending. So we are just following the statute there. Then I'll toss back to Torin.
Sure. So on 18438.6, and this is where we had the discussion about county central committees and candidates for those types of committees being falling under 84308. Again, at least my view is that while this analysis is spelled out in an advice letter, staff was basically just applying two different statutory provisions of the Act to the facts. And so I think even if we didn't make this change, if the commission chose not to make this change going forward, I think the correct interpretation under statute would be the same outcome.
And just to add to that, when drafting the regulation initially, I don't think that it was intended to be like an exhaustive list because the statute, I believe, requires that it specifies that it applies to any committee controlled by the official or candidate. So I think that the committees that we initially included were primarily just the most common, the the types of committees we anticipated being the most, commonly at issue. So this is just further clarifying that.
Yeah, and the regulation itself is including but not limited to.
Yeah.
And in a sense, we're not so much codifying advice letter here as we're just reflecting what's in the Political Reform Act.
Right.
Okay.
And then with 0.7, 18438.7, in amending subdivision B to include reference to subdivision D, this is discretionary in that we could establish a different standard than what we are suggesting in tying it to the same standards that we use in determining whether they have willfully or knowingly received a contribution. I think that in this context, the phrases are substantively so similar that given that we have discretion and leeway in terms of implementing, interpreting, and putting into effect the statute, that I think just for efficiency's sake, it makes sense to apply the same standards here.
Great.
But yeah, again, just discretionary. And then 18438.8, that standard is discretionary. We do have to, under section 84308, it does now specify essentially a longer timeline, more leeway for the parties to make their disclosure. And I think that was in part envisioning certain projects, especially like development projects that might be multi-year proceedings where essentially months might happen before, or months or even, more than a year might happen before any sort of decision is made by the agency, allowing, I guess, more time to pass so that if by the time the agency does make a decision, there has been more than 12 months since any sort of contribution was made, then no disclosure was necessary in that context. So the language we're proposing here is discretionary in that the 30 days is more of staff's suggestion. I think that it is a good compromise in the sense that it provides a much longer period of time, or 30 days prior to the agency making any sort of decision. It allows much longer period for the party to make any sort of disclosure while still providing enough time for review by the public official. And I don't think that the intent in amending the statute was to allow any sort of party to make a disclosure, the moment before a decision is made. So that is our recommended language, but again, discretionary.
Great.
So moving on to the last two, again, 18360.1, this is the eligibility requirements for Streamline, warning letters, and the PrEP program. The dollar amount changes are just now required by statute because otherwise they're out of date. But of course, Mr. Chair, as you noted, it's up to the Commission's discretion as to the actual inclusion of certain violations and the eligibility requirements around those. And likewise with 18705, I think same story there.
That's helpful. Okay, great. I'm glad we ran through that. One thing that I would ask the legal division to do is reach out to the organizations that represent cities and counties who are going to be most impacted by this, maybe Special District Association as well. Just let them know, if they don't already know, that these are up for consideration. You could also, I think it'd be helpful to let them know the minute mark of this item, as well as when we ran through what's discretionary versus what's reflected in statute. And hopefully we'll get comment well ahead of the considered adoption in March. Any other comments from commissioners? Commissioner Baker?
Thank you. I appreciate that. Echo strongly reaching out proactively. You might include the Joint Powers Authority Association. I think that's another one that could fall into that category. Just going back to the one towards the end here that you identified, I think it was 183. Well, it's the one where you mentioned the 30 days. You're taking it from, that 30-day period. Maybe when this comes back, I'll do more homework on this. But the question that's coming to mind is, does that, by setting that time frame, would that allow an elected official for whom there's a development application that's been pending for a while, that before the 30 days kicked in, can that elected official who's received a contribution weigh in, maybe not at a meeting, but with the city, and say, hey, have you thought about making these changes or those changes? Somehow influence the nature of the application and the final decision so that by the time it comes to the entity, they've had a chance now to, maybe because they got a contribution or maybe because of the merits, shape and influence something they otherwise potentially could have had to be recused from. I don't know that you have to answer that now. I'm giving you a preview. I know I'm going to have that question if I'm still on the commission at the time this comes back. And that's what's occurring to me by narrowing the time frame. If it opens up the possibility of conduct that that the statute is meant to avoid.
Yeah, and I think that is in part what we're attempting to address with the amendment to 1843.7 in clarifying the standards for when an officer knew or should have known about a contribution separate from, the fact that disclosure was made by the party.
Thank you, Chair. Commissioner Baker raised some, key points about reaching out to organizations and associations that interact with elected officials, special districts. We're talking about hundreds of individuals. Based on the first iteration of this statute, before these changes were made, do we have any idea what kind of feedback we receive at the local level in terms of information being disseminated, elected officials being brought up to speed by their legal advisors on the original iteration of 84308?
Yeah, I don't have the actual data in front of me.
It's just generally speaking. I'm not looking for statistical analysis or anything.
I can say that we have made a lot of educational materials available. Both Torrin and I have regularly hosted online training sessions going through not just the basics, but many of the nuances and most common issues that organizations are likely to encounter. When we have received outreach from large organizations that I guess nonprofit organizations, for example, we've tailored our training sessions to those types of organizations. And I believe that we typically get around 100 or so participants at each of those trainings, online, of course. And yeah, we regularly host those probably every other month. We haven't done so as much recently, given the regulatory amendments and recent changes to Section 84308. But as these regulations are, assuming some version of these amendments are adopted, we'll begin back up with updating our educational materials and hosting those training sessions again.
This mic is not really working well. The educational materials provided by the FPPC are excellent. And you and Councilor Lewis have done a great job outlining how this law would work.
Mm-hmm.
But if I'm an elected official in a small city and I rely on my county council or my city attorney to give me advice, to what extent would that be taken into account if that advice was not consistent with the law, and then there's an action filed against me? It's more of a hypothetical.
Yeah,
scenario.
I mean, I think that ignorance of the law isn't necessarily going to be a strong defense in a lot of these situations, but or in most legal context, but actual knowledge of, certain facts relating to the proceedings, such as,
Mr. Cornwall, sorry to interrupt you.
Yeah.
I think I'm going to throw this one over to Executive Director.
Yeah, not a
West.
legal division question, Kevin. So with any circumstance under enforcement, it's going to be fact specific. So if they got advice that the county council, or whoever it is, that confirms that they gave this advice and it was incorrect advice, that'll be taken in consideration, just as it was in any other enforcement action.
And just to add to your prior question, we received, me personally received more questions and comments and had more discussions about the changes to A438 in 2023 than anything else I've done in the years I've been here. So the public is very aware of this issue. Even the business community, people I know in my personal life are asking me about this who don't normally care at all about what we do. So this issue is known and out there, and I'm sure if people have issues with it, we will be hearing from them.
I always thought you had a more extensive personal life, but on this,
Not at all.
but also on a serious note, I want to commend the work that I've observed since I've been on the commission in terms of the fact sheets, Q&As, information that's disseminated to elected officials, appointees, and so forth. So to the extent there can be that continued education, I think that would be beneficial. So thank you.
Do we have any public comment on this item? Go ahead. You can go ahead.
Good morning. Good morning. My name is Alina Kasparian. I am the project director in the executive office of the Board of Supervisors in Los Angeles County. I oversee the administration of compliance with the Levine Act and work closely with our Office of County Counsel. First, I want to thank the FPPC for the continued efforts in providing clarity and guidance on Government Code 84308. We appreciate the efforts and look forward to additional guidance with the amended changes. As you know, Los Angeles County is the largest county by population, serving approximately 10 million constituents. Naturally, our board meetings often include several agenda items that pertain to matters subject to the Levine Act. Our office works closely with over 38 county departments or entities to ensure compliance with the Government Code 84308. While the recent amendments to Government Code 84308 have provided additional clarity and eased the administration of the Levine Act in Los Angeles County, some aspects of the amendment still remain unclear. I would like to highlight several areas where questions have come up where additional guidance from FPPC would be beneficial. The definition of a competitive process and whether it means contracts required by law to be awarded to the lowest responsible bidder or whether it includes all bid proposal processes. The definition of a development agreement and periodic review or renewal. It remains unclear whether the $250 or $500 contribution threshold would apply to proceedings that are initiated in 2024 but don't come before the board until 2025 for a decision. And similarly, it also remains unclear whether the exemptions under the amended law apply to proceedings that were initiated in 2024 but don't come before the board until 2025 for a decision. With that, I conclude my comments and want to thank the Commission for the opportunity to speak.
Those are some excellent points, and we really appreciate you raising those, and those are going to be considered and addressed. Any other, go ahead, Commissioner Wilson.
This is not something I would have raised before, but the last presenter referenced the Levine Act. Well, that's how the assembly member who authored this legislation back in the 80s pronounced his name. There have been subsequent members of the legislature who use the pronunciation of Levine. So Levine and Levine have been interchanged over the last several decades. So LA County, of course, nailed it. Thank you.
Thanks again. He was from LA. Commissioner Baker.
Great point. I appreciate very much the public comment about the time issue. We've confronted this so many times. What proceedings count when we have changes, and whether the statute or regulations. So thank you to taking the time for waiting to this public comment point, because that is super critical. It's something that we try with legislation that we are working on with the legislature to always have on a checklist of questions. What becomes effective, what proceedings when, so that we don't have to unravel that in a regulatory process. I just wanted to thank the commenter for pointing that out. Very important.
Agreed. Any other public comment? And thank you again for staying on through that entire discussion and presenting comment. We appreciate it. Okay, this is pre-notice, so we're not going to take any action. I'm going to suggest that we take just 5 minutes or so for a quick break. So how about we come back and reconvene at 12:05? General Counsel Bainbridge, do we need to make a motion to break for 5 minutes? Okay, so we can go ahead and do that.
Yeah, he was very particular about how his name was pronounced.
I think we're ready now.
Okay, great. Well, we're coming back here at 12:10, and we have at the table Senior Commission Counsel Zach Norton. He's going to be walking us through item number 9, adoption of proposed amendment of Regulation 18531.2, refunding of general election contributions after withdrawal of a candidate. Mr. Norton, I know that we received public comment on this item from the legislature requesting that we not adopt this regulation. So I think it'd be helpful if you could walk through what we're proposing, why we feel that it's appropriate, and then walk through the concerns of the legislature. And then we can open it for wider discussion for commissioners and public commenters.
Yes, I'll do that, Chair.
Excellent, thank you.
So today, for adoption, staff presents amendments to Regulation 18531.2. And staff originally proposed amendments for pre-notice at the Commission's August 2023 meeting. However, before the Commission adopted the proposed amendments, the legislature intervened by enacting statutory amendments which addressed most of the issues raised in pre-notice and made most of those proposed changes moot. And then at the Commission's November meeting, the Commission did request that adoption of this proposed regulatory amendment be postponed until January to allow for additional opportunity for public comment. So consequently, staff now presents amendments for adoption, which would implement the law as amended by recent legislation. And as the chair noted, we did receive a comment letter on this, which I will be addressing. So the recent legislation creates an exception in the general rule in section 85318, which allows fundraising for the general election during the primary election, as long as those funds for the two elections are kept separate. So being an exception to that rule, it should be construed narrowly, consistent with the fundamental canon of statutory construction, that our exceptions are to be construed strictly and narrowly. Recent statutory amendments provide that a candidate who does not file a declaration of candidacy to qualify for a primary election or special primary election is not defeated in the primary or special primary election and does not otherwise withdraw from the general election or special general election, and shall not be required to refund contributions. And the legislature chose specific language and explicitly added the filing of the declaration of candidacy, which is not a requirement contained in the Act, as a triggering event. So the proposed regulation gives significance to this language without reading it out of the statute. Staff proposed amendments adding language to the existing subdivision A of Regulation 18531.2, so the candidate would be required to refund general election contributions if the candidate withdraws after filing a declaration of candidacy. Because under existing law, a candidate must refund leftover money when the candidate does not run in or withdraws from a general election. And at the time of Proposition 34's passage, staff notes that per election limits that it enacted created a closed system, meaning that each election was separate for contribution limit purposes. In additionally, Proposition 34 provides separate contribution limits for primary and general elections. So for purposes of the Act's contribution limits, a primary and a general election are considered different elections. And if the legislature had intended to allow the transfer of contributions after withdrawal from the primary election under all circumstances, it would reasonably expected that it would have clearly said so. And then I will go on to address public comment. So we did receive a comment from the authors of the legislation that we're discussing today, SB 948. And I think they oppose the adoption of our amendments today. They cite reasons including that the candidate for elected office had no legal option to withdraw from a primary election after filing nomination papers until a subsequent bill, AB 1784, had been enacted. So it's their position that our proposed regulation is inconsistent with sort of their intent in drafting. Pause for a second. Okay. And so I will point out that there is some case law addresses with examining legislative intent, and courts have consistently held that testimony regarding the subjective understanding or intent of individual lawmakers or understandings communicated outside of the approval process are generally irrelevant and inadmissible to prove legislative intent. And the California Supreme Court has repeatedly declined to discern legislative intent from comments by a bill's author because they reflect only the views of a single legislature instead of those of the legislature as a whole. So just to make that clear that we do have some guidance on how we would interpret these comments. And it's staff's position that the proposed regulatory amendment is consistent with the idea that withdrawal from the primary election would effectuate withdrawal from the general election for that office. It would achieve a consistent result as the refund of contributions upon withdrawal from a general election, and it would implement the recent statutory changes based on that plain language.
Do we have public comment on this? Okay. Hearing and seeing none, I'm going to open it up to conversation. For me, and I come a bit late into this process of examining this issue. I know this has been going on for years. I think the key consideration is clarity, reliable clarity as to what these rules are so the regulated community can follow what the rules are. So with that in mind, I think we have the option of adopting the regulation, right? And we have another option, which would be to defer to the legislature and allow them to clarify what the rule is here. Now, if we adopt our regulation, it's very possible that the legislature could go ahead and pass a law within the next few months that contradicts what we are adopting here. And then again, we're going to have confusion among the regulated community as to what the rule is. So I do have a concern, not so much necessarily with the arguments made in the letter, but with the idea of confusion among the regulated community, which is my main concern here, right? So with that, I'm going to open it up. Is there any other commissioner comments? Commissioner Wilson?
Thank you, Ms. Norton, for your detailed analysis, and I know that you and the staff did a lot of work on this particular issue. I looked up the actual analysis, SB 948. Did you or your staff or your colleagues get a chance to look at that particular analysis?
Yes, I did look at that. I didn't find anything I thought provided additional clarity on this.
Yeah, I would, from what I can tell, is if we move forward with this regulation, there could be some conflict because there was no opposition to the measure. And it seems to me that when it comes to whether the FPPC as a regulatory body can supersede legislative action, only legislators or legislative bodies can pass laws. So the argument that the provisions of this regulation should be adopted, I think is a question that the legislature should resolve ultimately, because we don't have the authority to enact laws. We have the authority to implement laws through regulations. And whether the merits of this regulation are good or bad, I think we're overstepping our authority if we create any confusion in not only the regulatory community, but in terms of, the public at large. So I would be opposed to these regulations, not on the merits per se, but on the grounds that as a regulatory body, that's the scope of our authority. So thank you.
Commissioner Baker?
Thank you. I'm grateful for Commissioner Wilson's observations. I am landing in a similar area where I would think it's best for us not to adopt these. First, I want to recognize These came forward originally because the legal division, and I'm sure in communication with throughout their team, were looking at, hey, we need to clarify this scenario. And you've been working hard on it, and we've had feedback throughout the process. And I appreciate that, but we can't ignore the reality, which is that there's a legislative voice that is saying this is not what we intend to have happen. Now, I don't think we should, in response to that, say, oh, the legislature is telling us what their intent was, so we should do something different to reflect that intent, because it's not in law. But there's a practical reality, which is if we pass this today, it's very likely, given how much they have paid attention to this issue, that it will be reversed. And so where does that put us with time, communication, repealing regs that we've adopted? And I also think the legislature would feel a little bit differently. You made a statement that if they intended to make this apply to all scenarios of withdrawal, they would have clearly stated so. Their interpretation is that a bill was passed after they passed theirs, and that kind of changed a scenario, a fact scenario that wasn't in place at the time. Given that they see it differently, these same members have been very clear, this is where we want to go with this. I would not adopt the regulations. I would do something very similar to what we did, I think it was last year, which is come the end of this session, if they have not passed a bill that implements their expressed intent, and that we could then take these up. Fortunately, this is a pretty narrow scenario. I know there are some special elections that are out there happening. They are special elections as opposed to traditional primary and a traditional general election. So I think the likelihood of this coming up in that 9 or 10 month period is extremely narrow. I'm open to being convinced otherwise, so that we might be able to take advantage of going back to the legislature and saying, well, I know you think this was the intent and therefore we should act a certain way, but more likely you're probably going to repeal this. Why don't you pass a law? Put an urgency clause. You probably have to have a 2/3 vote anyway and get this to happen. You have the power to do that. Go forth and do it. It's better for the legislature to make law instead of write to us, this is what the law should be under the terms that we have. And that would be my suggestion, realizing that that is putting off, once again, recommendations that have come to us multiple times, including as recently as late last year. That's what I'm comfortable with doing. I just wanted to make it clear, it's not because we received a letter from the legislature saying, here's the intent, you implement the intent. It is because we're saying, you pass the law, and we don't want to be inefficient by adopting a reg that's likely to get repealed and going through that process. And there are very clear statutory canons, interpretation canons about what is legislative intent and what can be used, including in an analysis. 120 members have different reasons why they support a bill. And so thank you, colleagues, for considering that viewpoint.
Thank you, Chair. I agree with everything that has been said. I have a question. Are we hoping that the legislature will offer more clarification throughout the sessions, through the process, or are we just saying, okay, we're not going to do anything until the legislature takes action, or are we going to go back to them? I think that's what you were suggesting, maybe to say, we need more clarification. And thank you. And nothing like Commissioner Wilson said, nothing about the merits. Is the whole relation between commission and the legislature who enacts the laws.
Yes, and I can respond to it. So I think, just kind of to paraphrase what Commissioner Baker has indicated here, is that if the legislature is expressing to us that this is how this should be interpreted, then an option for you as the commission would be to say, all right, fine, we will take no action on this, because that is certainly an option before you, is just to take no action on these changes, and it will stay as it exists now without those amendments. And then let the legislature then say, okay, now that we did mean this, and we will now implement a statutory change to make it clear that this is exactly what we meant, rather than telling us, well, this is what we meant, and we would like you to make that change through regulation to further clarify what we meant when we passed the statute in the first place. So it's sort of it depends on who is doing the job of clarifying, and that also goes to what Commissioner Wilson has stated about the legislature having that authority to enact legislation, and that some things are best done legislature through rather than through regulation.
Thank you for laying that out, Mr. Norton. I agree with Commissioner Baker. I think her approach makes a lot of sense here. I do think that, we would see clarification through legislation here because we have a statute that, like you pointed out, like the legal divisions pointed out, previously lays out that threshold date, right? The filing of the declaration of candidacy. As Commissioner Baker pointed out, there was a change to kind of the election ecosystem that allows for withdrawal after that date. So again, so we can ensure that we have that clarity, reliable clarity, I think it makes sense for us to throw this back to the legislature, give them an opportunity to resolve this so that future commissions don't have to wrestle with this specific issue. Commissioner Baker?
Thank you. I think I would just add, in terms of mechanically what we're doing is, my proposal, I haven't put it in motion yet, is that we postpone adoption until, let's see, the legislature adjourns to September 15th. That's the latest by which they would have, can slip this into a bill and all the ways in which they do that. And that if it's not, that it be at our September meeting that we would adopt this provision. So I wouldn't withdraw it, or I think that's the mechanism that I would recommend. That also shows the legislature that we aren't making law based on a letter that's written to us about what the law is interpreted to mean, but it is, okay, we're giving you a chance to enact it, put it into statute. And if you don't, we'll be ready to adopt this almost immediately because we would have done all the pre-notice, all the public comment and otherwise. That would be my suggested mechanism for doing this, recognizing, that so much work has gone into it already.
Yeah, the only caveat I'd put in there, I'd want to make sure we address Commissioner Wilson's concerns in terms of authority, which I assume we absolutely would, should this come before us again. So if we sought to postpone this until that date, would we have to take any action?
You could just choose not to act on it at all, and that so you wouldn't be adopting it or rejecting it. You could just choose, sort of make a motion, as Commissioner Baker suggested, to bring it back in September if nothing has happened, but you wouldn't actually be required to reject it because the existing regulatory language would just remain in place absent any amendment. That's, yeah.
Commissioner Wilson?
That makes total sense.
Yes.
But at the same time, I think we have to be careful not to overstep our authority. The regulation might be good law, but that's not for us to decide. And so that'd be my only additional comment. From a process standpoint,
yes.
As Council Bainbridge, Chief Counsel Bainbridge said, you laid that out very clearly. So,
and I think it is our position that we do have the authority to make the changes proposed today, if that is the commission's desire. And if as Commissioner Baker has suggested, the legislature doesn't act and we do find ourselves bringing this back in September, I could also add in some additional material to the presentation discussing the extent of the commission's authority to implement and interpret the statutes under the act, which I think is fairly broad. We have it. I think we do have full authority to that. I can go into that if that's the commission's desire to have that discussion as to sort of the legal merits.
At some point, it would be helpful for you to go into that detail. The merits of the proposed regulation are not at issue. I mean,
yeah,
I think, staff did a lot of hard work on it. But in terms of whether we have the actual authority is the question. I saw the letter from the legislature after I'd already read all the materials. I can't prove that, but that's in fact the case. And I'm not clear we have that authority. But, I'm just one person, so thank you.
Okay, well, I suggest, consistent with what Commissioner Baker laid out, that we take no action on this item. And we move on to our next item, which would be item number 10, our legislative update. Okay, legislative update. I'm going to invite up here Lindsay Nakano, our senior FPPC legislative counsel. Good afternoon, Ms. Nakano.
All right. Good morning, Mr. Chair, Commissioners. I'm Lindsay Nakano, Senior Legislative Counsel. It feels like we just ended session, but we're back already. The legislature reconvened last week on the 6th. Staff have been meeting with members' offices on the Commission's proposals, and we do have interest from a number of offices. So far, one spot bill or placeholder bill has been introduced that may ultimately affect the Commission. I'll keep the Commission updated as we secure authors and as other Commission-related bills are introduced. Today, I wanted to revisit one proposal that I believe we had put on hold in November, which would require public officials to disclose arrangements for prospective employment on the official's Form 700 or Statement of Economic Interests. Commissioner Baker had raised the point that we should consider who would be making this disclosure, including under what circumstances. The proposal would be limited to arrangements for prospective employment, which is defined in regulation to mean acceptance of an employer's offer of employment. So disclosure under this proposal would be required only if the official accepts the offer of employment and the date of acceptance would be disclosed. Merely interviewing or negotiating employment would not be disclosed. Most often, I think this would likely be disclosed on the official's leaving office statement. So with that, I wanted to reopen the proposal for discussion. Any questions and any direction from the Commission?
Excellent. Thanks for bringing that one back. Personally, I think that's very important disclosure to be made. It's one of the few areas where there could be a conflict of interest for a public official, where the disclosure of the nature of the economic interest is non-existent, right? So the public is unaware of whether there was actually an arrangement of prospective employment while that elected official was in office. I think it's important to tailor it in many of the respects that Commissioner Baker pointed out. I think this is initially more appropriate for elected officials, perhaps even state officials. That's something that we can discuss. But I think it's a necessary reform and something that's been highlighted in the press as a area of the law that could use revising. Commissioner Baker?
Thank you, Mr. Chair. I agree. I wouldn't necessarily significant, and I think that's part of the conversation to continue having. You mentioned something at the end of your presentation that I need a refresher on. Is would this normally be disclosed on the leaving office Form 700? Would the nature of that normally be disclosed?
Not currently. No.
Okay. Oh, can you reiterate the point you were making about the leaving office statement?
Yes, I think my point was on what kind of statement this would likely be on. Not on their annual unless they delayed their employment, most likely on their leaving office statement.
Okay, and thank you. Appreciate that. I think that's all that I wanted to clarify. Is I do think appointed office would be good to explore because they're very significant appointed positions, and if it's on the leave, at least I don't have an opinion yet if it's on the annual Form 700 or the leaving office. But if somebody has negotiated something well in advance, I think that should be on a Form 700 if they're going to remain in office for a while. The final one is the leaving office. Is that 30 days after somebody leaves office?
Yes.
Okay, so whereas the annual statement doesn't, somebody could enter an arrangement in, say, May, and they don't have to disclose it until the following year if they remain in office. So there quite a bit of time could go by where that information is not disclosed. I don't know if we want to address that in any way. Thank you.
Ms. Nakano was laying out there is that the Form 700, the Statement of Economic Interest, will be the vehicle that we're proposing the disclosure occur on. It's possible that disclosure occurs on an annual or a leaving office. It will really depend on the date in which the arrangement occurred, right? So in the example you gave, if someone in May of 2025 is offered a position, they agree to take that position once they're done in their current capacity. And they serve through the rest of 2025 and go ahead and file their annual on March 1st of 2026, they would then disclose it on an annual. However, if they left in, let's say, June of 2025, they would disclose it on their leaving office Form 700. And we're not married to the idea of including it on the statement of economic interest, but I think practically it makes the most sense for elected officials. I think having all your economic interest disclosed on the same form makes sense. I don't think there's a particular urgency to this type of economic interest versus income, gifts, stock holdings, the other types of economic interests that are included on the Form 700. So that's the vehicle that I would suggest using for this. Great. Does the commission have any other concerns prior to us reaching out to offices to find an author for this sort of policy? Commissioner Baker?
It just takes some work to identify that appointed world, like what's going to be the potential cutoff, because there's people who are appointed to an arts commission locally, and then there's people who are appointed to commissions that get them six-figure salaries, and they're potentially two different things. So we'll really welcome some robust conversation about that.
In terms of the calendar, Ms. Nakano, if we wait to discuss this at the February meeting, will any deadlines pass that are particularly relevant?
Would that be kind of putting on hold, talking to other offices or talking to the legislature about this until after the February meeting?
Correct.
I think so. We're running into
Yeah.
some deadlines as Commissioner Wilson's nodding his head. That would put us in a more difficult position.
So then I would say, so we have the issue of the scope of this legislation. I would propose initially that the commission goes out and finds an author who's interested in this general issue. And then we discuss with them scope, and then that's something that we can continue to discuss as a commission and discuss with the author.
Yes, or if you
No, go
raise
ahead,
my
Commissioner
hand, but
Baker.
yes, that was my intent of my feedback, was to agree with you to go forward, and that'll just be part of the conversation. Thank you.
Excellent. Commissioner Wilson?
Yeah, I'm assuming, can't speak for Councilman Nakano, but she will probably, I'm assuming, talk to the chairs of the appropriate committees and or the leadership so that you don't find an author and then find out that the author doesn't have any traction on this idea. So, but I'm assuming you'll do that anyway, so thank you.
Yes, we're always in close communication with the Assembly Elections Committees.
Excellent. Do we have any update as to whether we have any authors locked down for any of these bills?
Discussions are still happening. We don't have any firm commitment yet, but we are getting interest. I think folks are still making final decisions on their legislative packages for the year. And the bill limit this year went down from 50 to 35, so they're being more conservative about and careful about what they're choosing to author this year.
Okay, and what are some deadlines that we should keep in mind?
Let me look at my report. February 21st is the last day for bills to be introduced. That's kind of one of the first big one for us. So before that time, we'll have to have submitted language requests to the Office of Legislative Counsel, and the last day to submit requests for that is January 24th. We do have the option of spot bills, placeholder bills, if we're still working on language in the meantime, but those are the big ones coming up.
Excellent. Any other comments from commissioners? Any public comment on the legislative update? Hearing and seeing none, why don't we move on to item 11, and that's going to be our executive staff reports. So first I'll welcome Mr. Lindsay back to the table. Good afternoon, Mr. Lindsay.
Good afternoon. James Lindsay, Enforcement Chief. I'm here to present not only the Enforcement Executive Staff Report, but a policy directives update, as is asked for We have a PowerPoint presentation to go through the policy directives progress report, which will put some data from 2024 into context and give the commission a good idea of what enforcement's been doing and how the policy directives are moving forward, especially in the context of what was a very busy election year. I think 2024, you will find, was a really good year for enforcement. I'm really proud of the efforts of staff to make this year end the way that it did. A brief reminder of the policy directives. We sort of have two volume-driven directives that we've been talking about. One was to reduce our pre-2023 active caseload by 75% by the end of last year, and also to reduce our active caseload or carryover caseload as soon as practicable to the number of 625 active cases. And then there is a general directive also, or desire to try to make sure that our complaint and referral and case life cycle is a 2-year life cycle when possible, to strive for that. We have the directives ask for these reports on a quarterly basis. We have informally through the commission have relaxed that a little bit. The last time that we did one of these was in June of last year. Although we didn't finish in June, we did carry over into August. So this is the first time since then that we have done a report. Some of these slides are similar to what you've seen before, but they're augmented for new information, and some are completely new slides. I'll let you know as we get through those. This is the simple slide that you've seen before, which is a graphical representation of the number of case closures that enforcement has had not only last year, but historically, a four-year comparison, which is what the policy directives have asked for. As you can see, our 2024 in terms of case closures was not only an improvement, it was a phenomenal improvement over 2023 or the previous years that's being compared to here. It's the highest number of case closures that we've had since I believe 2016. We'll go into a little more detail on that. But if we go back, you can see that the yellow graphic is for this year. Generally speaking, the yellow chart or graph is above all the other years previous to that. There certainly have been points in time of the previous 3 years where there were high numbers of case closures in a particular month, but 2024 was phenomenal for enforcement in terms of the number of closures that we've had. As I reported in September briefly as part of our executive staff report, we had actually achieved Directive 1 a little bit earlier than what was mandated, and that again is the 75% reduction of pre-2023 cases. We had focused heavily on the older cases specifically within that. You can see the year of generation of the case, how many of those cases existed at the time the policy directives were adopted, and then how many of those cases in a given year existed at the end of last year. We don't have any more 2016 or 2017 cases. We have just 5 2018 cases. Those are all very active, including a matter that is set for administrative hearing in March. And again, just a significant reduction in every area of year. For that, we reduced that number by 1,159 cases, which achieved an 82% reduction for at the end of last year. Yeah. No questions anytime.
The reduction of cases, I don't want to put you on the spot like today, but do we have a sense of what has been the impact, just generally speaking, from a percentage standpoint on the total number of cases?
Yeah, I mean, the lion's share of our cases go through the streamlined process in one way or another. It's been a massive impact on our ability to move cases, whether they're with violation or where appropriate with warning letter. PrEP has been an important part as well. We'll get into some of the greater specifics of those, but the general answer to your question is that streamline has been huge and has made a vast change and difference in how cases are processed through enforcement.
Yeah, it was previously alluded to, but in terms of the history and background of streamlining. I know in her prior role as Chief of Enforcement, Executive Director West was involved in that. So to the extent, maybe we can have another overview of the streamlining process, particularly for the benefit of any new commissioners, as well as Commissioner Ortiz, I think would be very beneficial. But that's the chair's call.
That's a great idea, as part of a future presentation.
Okay.
Yeah, so you can go ahead.
Don't get voted down.
So moving on to the second directive, which is to try to get to an active caseload or carryover caseload of 625. We're making significant progress in that area. We haven't been able to achieve that directive yet, but we have achieved about 75% of the directive, meaning that at the end of 2022, we had 1,415 active cases. We've reduced that number by 595 over the last 2 years. And now at the end of last year, we were sitting at 820 active cases, which is the lowest open case total that the Enforcement Division has had since sometime in 2015. The carryover case number at the end of 2015 was 885 cases. Previous to that, it was lower than 820. So sometime in 2015 is where we are at today or at the end of last year is where we are there. And I wanted to just give a brief 2024 snapshot to give some context to our ability to continue to move forward with that number. As you might recall, at the end of 2023, we had 954 active cases. We got the highest number of complaints ever in a year last year in the Enforcement Division. We opened the highest number of cases since 2019. We increased significantly the number of matters that were finalized with monetary penalty. That was more than a 50% increase over 2023. We more than doubled the amount of monetary penalties, aggregate monetary penalties. And even with all of that, we managed to reduce the case number down another 134 cases to the 820 number that you see there. And I'll get into a little more detail specifically on the number of complaints and all of that, but I just wanted to provide a backdrop there on terms of the amount of volume that the Enforcement Division experienced, the type of resolutions, and still the ability to move the case numbers the way that we did. This, I think, is actually arguably the most important slide that we have today. It's a new slide. It's a representation of what the practical effect is of what has happened. But I need to make sure that we're sort of reading the chart in a way that makes sense. It's obvious if you just move from left to right over the course of time, a case that you generated in a particular year is going to be less than it was before. There's nothing particularly interesting about that. So when you see that, for instance, at the top that there were 3 cases from 2016 and now there's none, okay, that's okay. What we want to do to see what this really means, though, is to look over one column and look down one column, because that reflects the amount of time each year that a case has aged. So for instance, when you look just before the policy directives were adopted at the end of 2022, we had a fairly limited number of cases that were 5 years and older, because the statute of limitations is 5 years. You have to act in some way. Those cases are always going to be pretty low because you have to focus on those and resolve those in some way. But we had a lot of cases, 105 cases at that time that were from 2018, cases that were about to hit the statute of limitations. And so at that point in time, I would say that Enforcement Division was heavily involved in trying to put out fires on cases that were ending their spot where they needed to be resolved in some fashion, or at least tolling the statute of limitations. If you look one column over and down, you'll see that that same time frame at the end of 2023, there are only 39 of those cases. So that's where you see the big change last year in terms of the composition of our cases and how much we were improving in terms of what was, sort of on the cusp of being a case that we had to seriously pay attention to. There was a more than 50% reduction from that 2018 number in 2022 at the end of 2022 to the 2019 number at the end of 2023. There were improvements in the 2020 and 2021 as well, but those were those were more like 20% differences. What you see for this year now is that, of course, there's a limited number of cases that are close to 5 years or whatever, because there are always going to be some cases that you can't conclude for whatever reason within the time frame that you would like. You have to go through all the processes. You have difficulties with getting the respondent's attention, going through and getting investigation. So there's always going to be cases that linger. The question is that a normal result, or is that something that's an outlier? And what you'll see now is that not only, you look at the 153 number in the 2020 category, in 2023 you move over and down. Now we only have 68 cases that are from 2021 this year. And so we have essentially last year, we brought it down, the big number down a year, and now we've brought it down again an additional year at the end of last year, such that the age of our cases is significantly different. And that's what the last row relates to, is the median age of our cases. At the end of 2022, the median age of a case in the Enforcement Division was 22 months. At the end of the 2023, we had moved it down to 19 months. At the end of last month, the end of last year, we had reduced the median age of our cases all the way down to 15 months. And again, the meaning of that is that almost half of our cases at the end of last year were generated last year. So if you looked at the very midpoint, that was a case that was generated in October of 2023. That's a much healthier situation where we are now able, in a much better way, to handle cases that are able to be resolved versus ones that we just have to look at because we're running out of time. We're not running out of time, generally speaking. At this point, we are operating on a basis where if a case is generated relatively recently and it's a case that has the ability to have an appropriate resolution, we are getting an appropriate resolution. And that comports with a good number of our streamline reports over the last year, where we're seeing a lot of 2023 and 2024 cases resolved. We are focusing and able to focus on a lot of those cases and being able to look at not just the time or how old a case is, but whether it's a case that needs to have attention right away and whether or not it can be resolved. And if there are specific questions about that, you can stop me. But that's, I think, a really good representation of what the actual practical effect is on enforcement and how the case reduction changes the composition of things and how we're able to operate as a result.
Quick question for you. We're coming up to, we're in budget season. So I think it'd be helpful for the public to have an idea of what could help us get these numbers down even further. With staff, IT, what's your perspective on that?
Well, I do think that staff, we did have an influx of staff last year and the year before. I mean, clearly that's been helpful as well. Anytime you can get more staff, you can definitely, handle more items. Whether or not that's realistic or not, I don't know. I'll leave that to others. But yeah, sure. If we can get more staff, then it would be helpful. I think that we're doing really well with the staff that we have as well. I think that the fact that we're able to make we've been able to have the movements that we've had has been, and I don't think we've plateaued. I think that we will continue to see positives. We'll have some new things come up next year because there always are, but we won't have an election year, that will reduce complaints historically. We are, as I will show you, we are potentially in a reduction mode in terms of referrals. We got fewer referrals last year. So I think that we will have fewer open cases more likely than not next year. And my hope is that we will be able to continue to reduce our numbers throughout next year.
Thank you.
Again, to talk about the 2-year life cycle, obviously when you start reducing median case age, you know that that's having an impact on whether or not we're reducing things through the 2-year cycle. It's important to note that the directives themselves just turned 2 years old at the end of the year. So we don't have any discrete data points really to say, okay, this is what we had 2 years ago. This is how many cases we have now. But future reports will have discrete data sets potentially. So I would think that at the middle of next year, we could specifically look at, okay, what happened at the beginning? What did we have at the beginning of 2023? What do we have now? What I can tell you in terms of data is that, as I'd reported before, 66% of our cases that were opened in 2023 were closed in 2023. That number went up to 71% in 2024. And roughly 76% of the cases opened in 2023 are resolved now. Now, again, a lot of those cases aren't 2 years old. They could have been opened at the later part of 2023, so that's not a perfect data set. But 76% is a pretty good number in and of itself, and I suspect that number is going to go up to some degree. Although there is always going to be cases, as I said, and as I'm sure the Commission knows, there are always going to be cases that, for whatever reason, aren't going to be resolved within 2 years. This slide will give you some specifics on the data comparisons for the complaints. As you can see, this was the highest number of complaints in 2024, and 1390 previously was pretty easily the highest, and 1379. Those were pretty easily the highest numbers before received in complaints. Our complaint numbers are generally going up, whether they're in election years or non-election years. That sounds like it's a bad thing, but generally speaking, in enforcement theory, that generally relates to the fact that it shows that the public has a good confidence in what the enforcement division is doing. That if people feel like their complaint is not going to go anywhere or be handled properly, they just simply will become apathetic and not file or submit complaints. The fact that we get complaints and those numbers are going higher indicates to me that there's good public confidence in what the Commission is doing and what the enforcement division is doing. As you see here, for the first time in a while, there was a fairly significant decrease in the amount of filing officer referrals that we received. I also think that that's a good thing because those types of scenarios are usually for non-filers of SEIs and things of that nature. I think that we may be seeing a good effect of the PrEP program. And it was initiated in 2022. I think we're seeing fewer people get. We're accustomed to seeing the same individuals a lot of times get multiple referrals. And so I think that that's a big factor in why we're getting fewer referrals. And also, we've expended a great deal of time in prosecution of those types of matters that we get referrals from. And I think that there's good public education in both ways to get those filings to occur. We did open significantly more cases last year, as you can see, than we had in the previous years. And it is the most number of cases that we've opened, I think, since 2016. I think that there's the next slide may say that. The number of cases that are open is a function of two things. It's a function, obviously, of the high number of complaints, but we're doing an excellent job of thoroughly reviewing, even during the heavy volume of the election season, we were doing a very good job of thoroughly reviewing those complaints and making very reasoned decisions about whether that complaint should be opened into a case or not. So it's not, the high number of case openings is not related to a relaxing of standards in terms of whether to open the case from a complaint or not. It's largely due as well to the fact that we have been able to significantly reduce over the last year the number of unaddressed previous referrals that we had. A lot of times those cases will be opened into cases, and we were able to address referrals in a way that we hadn't been able to previously, and so that number has gone significantly downward in terms of the number of referrals that we have.
Thank you. I thought I would just chime in, because you're right at that point now. Can you say more, first of all, on the, I'm sure I believe it, the excellent job. What specifically are you doing differently during that intake process to evaluate whether a case should be open that wasn't done before?
I think that we have, first of all, we've had a restructuring of intake a little bit. We've got, our PRCs do a really good job of getting to their material, looking at it. We've got, we are focusing quite a bit on whether or not a complaint has sufficient information under the regulation to move forward with that complaint into a case. We also have attorneys in intake now that are in those more complicated areas such as conflicts and things of that nature. We are engaging the practice of attorneys in looking at those cases more specifically. And instead of simply opening a case and having it investigated, we are looking at the legal issues from the front end. Mm-hmm. And we've been able to reduce the number of cases that shouldn't be opened at the inception. With respect to referrals, we simply have more staff. We were able to get additional SSA positions that are looking at referrals, and they're doing a great job of reducing those numbers.
So going back to the cases that shouldn't be opened, that maybe the more experienced attorneys are looking at, is an example where it shouldn't be opened is during intake we got more from the respondent so that we can see, oh, turns out this isn't an issue. Maybe they're wrong. Something was filed and it's just not showing up on the Secretary of State's website, or something did happen and they were able to quickly provide, basically say, this isn't a valid claim, or is it that they look at it and it shouldn't be open because you don't think it'll lead, that evidence will be there. Those are two very different scenarios. One is perhaps you're engaging more, you're giving the intake process more opportunity to cut the issue off at the pass. And the other is, we don't anticipate after 3 years we'd be able to get any more information. Can you elaborate on that?
Yeah, it's both. We are engaging with individuals and requesting documentation. A lot of times a respondent will be able to provide documentation that shows that the complaint is not accurate. Okay. And doesn't mean that the complaint wasn't legitimate or they didn't think that it was real, but we've been able to sort of truncate that process by getting contrary evidence that shows that there's not a violation. We're able to identify much better, generally speaking, I think, where there's not, the allegations do not fit within the purview of the PRA. We've been able to identify in certain instances where there simply is not a legal violation, maybe in a conflict of interest situation, maybe there's not a material change to somebody's financial interest or something like that. There's a lot of different scenarios where we can look at things a little more deeply. I think that when you're overloaded with cases, sometimes and you, especially in maybe a sworn complaint situation where you're under strict timelines, the safest thing to do, the thing is to say, okay, we're going to open this case and we're going to have it looked at a later time.
We'll get to it later, kind of.
Right.
Yeah, okay.
There's no danger necessarily in doing that other than the fact that it creates a lot of cases that are open that maybe shouldn't be open. And there's a lot of benefit in looking at something with a more discerning eye at the beginning, because it's better to, if there's not any possibility of a violation, it's better to close that matter out at the beginning and then have it sit around, obviously for an extended period of time.
I think that's great because it's also more fair to the respondent.
Sure.
Who might have to wait, hopefully not 5 years, but like a while to have there even be any communication or understanding that something is going to be closed, during which time they might have to run for re-election where somebody uses it against them. So I don't want to forget the benefit is our numbers and workload, but it also is perhaps more fair scenario for the respondent and certainty to happen. If I may, also on this intake changes, you mentioned that we look at a complaint and determine if there just isn't anything there. I'm also mindful that sometimes people who are filing complaints are not attorneys. There are I want to say ordinary citizens, but they're not ordinary. They're folks who aren't maybe versed in every provision of the statute, but perhaps they've stated enough and that maybe they cite something wrong or they don't provide as much evidence. How are you changing have you changed at all in the intake process, how you're looking at those? I'm trying to understand and watch out for more burden being put on the public to almost be like lawyers than not. And I would like I'd like to understand from you how you're looking at that to evaluate if that's happening and what you're seeing.
Yes, we do look beyond the complaint. We will, and we do open cases pretty frequently where something that was articulated in the complaint may not be accurate, may not lead to a case opening, but we may find something in the filings because we've looked at the filings due to the complaint. We may see that there actually are some violations there, and we do open those cases even though they weren't specifically articulated in the complaint. We never force people to be quasi-lawyers or anything like that. But in scenarios where the facts that are put out there, there's no evidentiary support for them, and we don't otherwise find any evidentiary support by looking at public filings, we aren't opening those cases.
Okay, thank you.
Sorry. I think that I understand complaints and referrals, but I would like to understand how does a complaint arrive versus a referral?
So a complaint comes through our portal, and it's usually from a member of the public.
Member of the public, okay.
They'll make a complaint that is termed a complaint here. Referrals come from filing officers and can even come from our own SEI unit here within the FPPC. And those are usually limited. The lion's share of those are related to SEI filings or non-filings. We do get some campaign referrals as well.
So the referrals come from the official people, and the other one, people's complaint. Thank you.
That's the easiest way to go through that. All right. So to get through some maybe some specific numbers, some specific metrics. Again, the 1,400 for intake. There were 1,452 complaints that we received is the highest number that we've ever received. And those numbers, will I would imagine probably go higher as we go forward down the line. Obviously, in non-election years, those numbers have been roughly 50%, maybe even less than 50% of what an election year will generate. I suspect that next year, or this year, excuse me, the complaint numbers will look more like what they looked like in 2021 and 2023. But I wouldn't necessarily be surprised that the number goes above what was in 2023. That's been the general movement thus far. The 1,402 cases is the highest number since 2019. I've explained why the two bases for that occurring. I wanted to give them a shout out as well. The number of stipulations that came through the intake unit significantly rose in 2024 from 2023. So not only are they handling complaints, are they handling error memos, things of that nature, but both attorney staff and support staff do send out stipulation to respondents, and they've been much more successful, doing a really good job of increasing those numbers.
Commissioner Baker?
Thank you. Just on that point, are you referring to mainline stipulations?
They did actually, they were responsible, the intake unit was responsible for 2 of our mainline stipulations last year, but generally it's a streamline. The intake unit handles cases that are much more specific, usually not investigation related type cases, usually, filing matters and stuff that you can determine what the violations are based upon the public filings.
Okay.
And so those usually are streamlinable.
Very helpful, because when you said stipulation, I'll have a question at the appropriate time about what the progress in the mainline and the volume of mainline stipulations coming to the commission. You were making a different point about stipulations just early in the process, like intake, before it ever gets further into an investigation?
Yeah, for the most part. Like I said, they do, especially our more senior attorneys in intake, they do have cases that are not, have violations that don't have streamline capability. And they did provide two of our main lines last year out of the 25 did come from intake, but that's not the typical scenario.
I thank you.
You're welcome. We are focusing, one of the things that we are doing to finish that up with intake, we are focusing on the movement of cases that a little more quickly, cases that they cannot get compliance on, cases that do not lead to stipulations. We are trying to move those to prosecutions faster than we have before, and we've had some success over the last 6 months of getting cases out of intake that do not seem to be cases that should be in intake any longer. Investigations and prosecutions, again, they took on a high volume last year because of the 1,402 open cases. Most of those cases come to our investigations and prosecutions. Not all of them, but the lion's share do. We closed the 1,536 cases last year. It's the highest total that we've had since 2016. You saw that number was significantly higher than the previous 4 years, previous 3 years on the earlier chart or graph. We are getting, again, we are continuing to keep our investigations unit moving on investigations that can be started even without attorney involvement. The typical scenario is to have the attorney receive a case, develop a plan, and have the investigator have input on that, finalize it, and start the investigation. Sometimes when you have high volume, in those situations, we can't get a plan right away. But in many instances, even when we can't, we've been able to get investigations rolling because, there are things that the investigators know that we need for that particular case. And we've been able to get investigations moving rapidly in many cases to keep the case or get the case moving, even if it's a little bit out of order. Again, our additional net reduction of 134 cases in 2024, despite that volume. And, it's important, I think, to talk about, the context in which that's happening, because there's always the fear that, the public could be of the and even you could be of the mindset that we're simply just closing cases. And that's not at all what the situation is. We are giving appropriate prosecution level to all of our cases. I think we've doing a great job of that and have had significant increases over the last year in terms of the number of cases that have generated a monetary penalty. And the $802,238 in total fines in 2023 was the highest number that we've had since 2020. So even in a case reduction scenario and following the directives the way that we have, I think that the performance metrics have not at all suffered in terms of what the type of resolutions that we're getting are. In addition, oh, go ahead. Oh, no, my fault. I probably should go. Yeah. And the only thing additionally I wanted to say is that our probable cause proceedings more than quadrupled last year. So what that really means is that we are getting to a spot where we are, we're getting into cases, we are engaging in discussions with people where we can, and then if that doesn't go anywhere, we are moving into deeper prosecution methods because, as I think I've articulated before, I think one of the ways to reduce cases a lot of times is to make sure that the regulated public understands that we're going to keep moving forward. You're not going to run the clock out. We're going to move forward and we're going to start closing doors for you. And we've been very successful implementing that in the past year.
Thank you. First three things, especially in response to your last point. Excellent, excellent, excellent.
Thank you.
You mentioned that you kind of raised the issue of, well, public might have the impression that we're just closing cases. And I think you might asterisk that and even or doing warning letters where we normally would have closed a case. And you're saying to us that's not happening. Can you say a little bit more about what you as the enforcement chief do to observe and watch for that, to have your own confidence that that's not happening? What either in your practices do you do? We've never really gotten into the nitty gritty of your day. I'm not looking for what does a typical day look like, but what is assuring you that that's not happening?
I probably get, on average, 10 to 15 matters that come into my queue every day for final approval on something, whether that's a warning letter or, a stipulation or a request for settlement authority, whatever it might be. I have a very good grasp of what we are doing and why. We do engage in a good number of warning letters, and if we look at beyond the slides here and we look into our actual report, our annual data shows that the warning letters were also higher than they've been, a little bit, not much, and certainly not to the level of the additional closures. The warning letter percentage went down last year, but the raw number went up. You're always going to need to send a good number of warning letters because certain things just simply don't merit a monetary fine. A lot of the warning letters, to be quite honest with you, are generated from the referrals because there are lots of situations, especially when you're looking at referrals that may have come in 2 years ago or something like that. A lot of times those people aren't in office any longer. There's a lot of reasons why, you want to get a resolution. You want to make sure that it's documented in case that person becomes a public official again or whatnot, but it may not merit, not doing a leaving office statement, for instance, when they've done them before. There could be a wide variety of reasons, but I can assure you that when we have a situation that merits something more than a warning letter, that merits a monetary penalty, we are going after that penalty. We are going after that stipulation.
And last one on this, if I may. Do you have, this is really getting into your own practices, so reveal what you like, but do you have a deadline on yourself for when matters are coming to you? And the reason I ask that question is a little over 2 years ago when we had the first draft of the guidelines, some of the feedback we received was, we're moving things along, but they at different stages that we're moving them along, they might maybe sit for a while, not because somebody's not doing their job, but they just made that observation to us. And I wonder if that is something that's affected, your practices, and do you have a deadline on yourself when you look at things?
I take that very seriously. My philosophy is and has always been that I should do the things that cause other people to be able to get their work done. I don't want to be the person that is the problem. I've got 3 things in my queue right now. I know exactly how many things I have in my queue right now. And I think that if you spoke to anybody privately within the enforcement division, I don't think a single person would say that I'm holding anybody back in terms of getting that work done.
Well, I've got a to-do list at my office and my other life that's much longer, and I am going to aspire to not be the one that holds other people back from getting to do their job. So thank you for letting me ask those at this point. I see Commissioner Wilson has some.
Commissioner Wilson?
Thank you for your detailed presentation. Now, this is just a general question. Let's say you get 10 cases, and of those 10 cases, 3, even half relate to public officials. The remaining cases might relate to someone who works at the staff level in a county. Do you prioritize how you address those cases, given the fact that the ones relating to public officials might trigger a call from the media? They may be more high profile. That would be helpful to kind of get a sense for how you deal with that particular scenario.
Yeah, in a vacuum, a matter that has to do with the public official, that would have some priority for sure. And we do treat it as such. Obviously, things aren't necessarily in a vacuum. We may have something with the staff person. We had a main line, I think, last month where we had serious 1090 violations. That might be something that we would move on more quickly than maybe a minor filing violation with a public official. But yes, as I understand your question, if all things were equal, we would definitely prioritize the public official. You're welcome.
And one other comment on this slide. I'd say, while I suspect and expect that the number of warning letters are going to go down in 2025 from 2024 and 2023, I think it's important to note that a warning letter is a finding of a violation.
It is.
And I think that should be when these sorts of matters are being covered by the public, the campaign context, by the media. That's an important thing to remember. Despite the fact that it has the connotation warning, right? It is a finding of a violation. That's a very serious thing that someone has violated the state's ethics rules.
Yeah, you're absolutely correct. And as you probably know as well, I mean, that warning letter has language that allows people to challenge that. If they don't find that the warning is appropriate and they want to have a hearing instead, they could theoretically do that. It doesn't happen very frequently, but it is a finding. It is a finding of a violation.
And is that a correct expectation? Is that a reasonable expectation that these warning letter numbers will be going down next year?
It probably depends on the number of cases that get closed. As we continue to get through and reduce the number of unaddressed referrals, that number could still be fairly high next year. It really depends on the type of case that gets opened and the manner in which it gets opened. So I suspect that if we continue to have the case closure numbers or case closure numbers that we've had, there's going to be a lot of those that are generated from referrals, opening referrals. And the opening of referrals does lead to a higher level, I would say, of warning letters percentage because of the type of violation it is. So I don't think I could
Well, to
make that
clarify
promise.
as direction in my role, I would say I would expect and hope that we lower this number next year.
Okay. I think that we'll just, I guess, have to see how the composition is.
Great. Well, you can go on.
Chair, could you elaborate on your rationale there?
Sure.
Not that I disagree with it, I just kind of want to better understand it.
Yeah, no, I think that's helpful, especially for the public. I believe that they're following the directives that were laid out by the commission there was additional discretion that was provided to enforcement for certain case resolutions. I believe those have expired. So we would expect that these numbers, the proportion of cases that are resolved versus, or I should say via warning letter, would be different than Streamline, or would be different than it has been over the past 2 years where Enforcement Division had that discretion. I'm open to hearing what the Enforcement Division or what you have to address that, but that would be my expectation.
Well,
I don't know
I-
what the expectation of other commissioners, but just this single commissioner, that would be my expectation.
I think the thought process there is that warning letters, where appropriate, are an important factor in being able to close cases as well. If we make a significant change on how we handle warning letters, I can assure you that those case numbers are going to go back up. How much they go back up, I guess that would we just have to see. I can't really predict that. But if we start, the alternative to warning letters is that we prosecute everybody. And when you start doing that, then I guarantee you things start slowing down. So keep that in mind.
Sure. Commissioner Wilson?
Wasn't planning to ask this question, but since we're getting in the weeds here, the question that I have is when a decision is made to issue a warning letter, who makes that decision at the senior staff level? One, and is the chair included in that process?
Not specifically. We go through our processes through the streamlined regulations, primarily for when something qualifies as a warning letter and when it doesn't. We look at our comparable resolutions of the past. And that's generally how it's determined that it's available and for a warning letter and it gets sent out.
And is the executive director involved at any level? I know there's a so-called firewall between the commission and enforcement, but as it relates to that decision, does the executive director ever weigh in? I'm just trying to understand the full process.
The daily process would be no. The daily process would be that I would have the ultimate final authority on whether or not a warning letter goes out based upon what has already occurred with the executive director's input and the commission's input. So we're implementing what has already been put out there by the commission and with the executive director's input. If we had a situation where a warning letter went out that I suppose somebody didn't agree with, or I may have ad hoc types of communications with the executive director over a close call or something like that. But generally speaking, that is handled within enforcement.
Thank you for that information.
You're welcome.
Executive Director West?
Sure, I would just add, this is the reason that we put the warning letter criteria into regulation, so that way it was approved by the commission. The commission has already set the standards, and then that way it could be delegated to be applied. So it was an efficiency move in order to make sure that the commission was the one making the decisions and giving the authority in order for staff to be able to implement it.
Right, but there's no appeal process.
Sure, they can go to hearing. Oh.
Commissioner Baker?
Thank you. A couple of points. There we go. There has been in the last year, I think it was, where a warning letter came forward that I had many questions about. I only became aware of it because it became the subject of a news article, because otherwise we don't see the warning letters. We see advice letters each month. We get an advice letter report, but we don't see the warning letters. So and there is that firewall that is appropriate. So I do want to point out, if we do become aware of one, we can raise it either by contacting, the way it's always been described to me, the Director West for queries, not you, and especially if the matter for some reason would still be open. I guess it isn't if it's a warning letter. To the chair's point, though, I think if there is discretion that was put in the guidelines, that there is an understanding kind of expires at the end of 2 years, I welcome and would encourage the team to provide the chair and the commission with an update on that. And if it needs to be, I think the chair is asking a fair question. You know, in the next few months, if not 2 months, there's going to be very new commissioners on here, and at least a couple. So I think that's an opportunity to refresh what discretion might be appropriate going forward. So I know you're not poo-pooing the chair's suggestion that the warning letters go down, but I am recognizing he's trying to keep the train moving forward, and that if there's something that's about to expire, it's worth coming back to this new commission, new chair, new composition, and reporting on that. I just want to encourage that, knowing that next month is probably my last meeting.
Yeah.
So thanks.
And I appreciate that, and always appreciate you having me right next to me. So I'm really going to miss you when you're gone, Commissioner Baker. With that, I totally agree. This is going to be a new commission makeup within the next few months, and it's very possible that the new commissioners have new priorities. The Enforcement Division has done an excellent job addressing some of the concerns laid out in the directives, especially the first one here, right? It's very possible the new commission is going to have different directives. And I would say one thing that I would suggest when we come back is that warning letter piece. And then as well, noting if there's any sort of additional discretion that's not provided in regulation for the Enforcement Division. So everybody's aware of that. Sounds good. Good job. Thank you. And then I think we're largely done. I just have this as a final basically shout out on what to continue doing what we've been doing in terms of focusing on moving cases, reducing the case age. We are right now fully staffed. We had 2 people join us this week, actually, a new PRC and a new Attorney 1 in prosecutions. We're going to be looking forward to further reduction of our carryover cases in 2025. So that's the end of the slides. There is additional information and a new, if we look at the staff report that is published as it usually is, that obviously has new data from 2024, and that may lead to some additional questions or comments. One of the, you know, as we've said, all the stipulation numbers are up. The fines have been up. Warning letters, since we've been talking about that, you can see that they were slightly up from last year, but the number of cases closed is 250 more for an additional 34 warning letters. So we've also seen significant increases. If you move over to page 4, significant increases in prep completion, and now we have campaign programs and advertisement programs that individuals are completing, which lead to no action closure letters if they do complete those programs. All right, I think that's everything I wanted to present, but can answer any additional questions. Any additional questions?
It might be my last hurrah for this, you know, and I want to point out, first of all, again, excellent that these are very material numbers that the team can be proud of, and it's much of this is the results that we had hoped would come from the guidelines being issued. A question I have for you, this one's is about the mainline stipulations. Over the course of this year, and I raised this at prior meetings, I felt or seemed to observe there on the agendas that we had, there were a significant drop in the mainline stips that were coming to us. There might have even been a couple of meetings where if there was 1, maybe there were 3. And when I first joined the commission, there could be 7 to 13. And there were even some meetings where there weren't any at all, and they were all default proceedings. And I think at one of those meetings I said, where's our mainline stipulations? Are we getting a backlog? Will it mean, 2-3 months from now, we're going to have an issue? Can you comment? I will say at the time, the response, which was very respectful, wasn't really satisfying to me, because it was like, well, this is what you can expect when we clear out the deck and we're going to see more we're going to focus on defaults more. And I may have interpreted wrong. Can you update your answer?
Yeah, I think maybe I wasn't as clear as I would have liked to have been. I think that actually the big issue is that things that if you look back in 2019 and 2020 and you see mainline cases in the 70s, a lot of those cases, the lion's share of those cases would not be mainlines anymore. The streamline regulations have taken over a lot of areas that simply lead to streamline stipulations instead of mainlines. If you look, for instance, I won't necessarily go over these, but if you look at total penalties just this month on our streamlines, 1681, 1307, 3742, 641, 1618, 3900.
They're going up.
Those are all would have been mainline stipulations. Almost all of them would have been mainline stipulations 4 years ago. So a lot of the streamline stipulations that you're seeing today would have been mainlines.
And is that because of, I apologize.
No.
Is that because discretion in the streamline or because of the metrics that were maybe either specified, or I should ask a more open-ended question. What role has discretion played in that?
There's no discretion to put something in streamline really that is a mainline offense. There's some discretion within streamline. So it's just that there's more violations and violation types that are amenable to being streamlined today than they were before. And so we're using the current streamline regulations to streamline, which is what the goal of the commission has been. It does help with case numbers. It helps with a lot of different things, but it does lower mainline stipulations. The mainline stipulations that we're seeing now are most significant violations, like the two cases that were before us today. I mean, they're misuse cases, they're conflict of interest cases, they're mass mailing at public expense cases, they're surplus funds cases. Those are the cases that we're seeing a lion's share of mainlines out of, and they're the ones that take the most investigation. They're the ones that take the longest. So we've increased our number of mainlines. I suspect that there's still a possibility that mainlines could go up over the next few years, especially as we continue to get a little better processing. I don't think that we're ever going to see numbers that are reported on this from the years of 2019 and 2020 because there simply aren't enough avenues anymore to have those types of numbers for mainline stipulations. Is that better?
It does.
Explanation?
It does. I was surprised here that there's no discretion to put something into streamline that would not otherwise qualify. Is that correct? Does the executive director have discretion of any kind to put something into streamline? Or you?
No, I don't. And the reason that it's written that way, I mean, actually, this is a success story. Tier 2 was written specifically to take the bulk of these cases that didn't have intent, didn't have the violations identified by the commission as where we wanted to spend our resources, and to put them into the streamline program with higher penalties. So this is actually exactly what the plan was, and it's working, and it actually is freeing up resources, and you're seeing results of all of the planning that's gone in for the last couple of years. But yes, the discretion to put something in streamline that would have been a mainline doesn't exist at the staff level because it was strictly written into a regulation so that with the freedom wasn't there to then not have it as a mainline case.
Okay.
And a derivative point that I might make is, I'll just anticipate a question.
Thanks.
Because you might think, okay, well, I understand that there's more streamlines, but there was a lot more streamlines than there are now too. And the answer to that question is, if you look back 5 years ago, for instance, you're going to see a ton of stipulations that are for $200 and $400.
Wow.
We just don't, because of our prep program, we are getting rid of a lot of that type of monetary enforcement. And so we're seeing not only, we're increasing the main lines to the streamlines, but we're also getting rid of a lot of the old streamlines through other alternative practices that the commission has decided, I think appropriately and correctly, that we don't want to spend a ton of time, resources chasing a $200 stipulation when we could just educate them and hopefully not have them return again.
Yeah. I just have a couple of real quick ones, but that I think are on this. One is, how is morale in the team from your observations? Because again, when these were first adopted, I felt there needed to be more input from staff on what they were experiencing so we could craft these reasonably while still, being accountable. How do you think the morale is under these guidelines?
I think the morale is great. I think it's higher than it was when I first joined.
Okay.
And I think that if we look at complaints and things of that nature internally, I dedicate almost zero time to those types of things. We meet regularly. I think when I'm in the office, my door's open. People always feel welcome to come in and voice whatever they want, and I do not spend a great deal of time with individuals that are upset about something.
That's usually outside the purview of commissioners. That's getting into the weed of administration, but it was something that had percolated up to us at the time. Only other is, there were 2 Cal Matters articles that came out about how long we're taking and so on. And I don't know that at this moment is the appropriate time to say, hey, do you want to do a point counterpoint? I welcome that at another time. But one of the questions, is there anything about that you would like to observe because it was such a public and for the most part criticism? And I think this is a success story that the team should be proud of, and so should you, or anything you'd like to say about that coverage based on what you're reporting to us today?
I think it's old news. I think it was old news when it was reported. I think that there was sufficient information available to the public to see that that was not the scenario that was happening even at the time that was authored. But I think that the numbers speak for themselves.
Okay.
We are moving through our cases efficiently, expeditiously. There is certainly room for improvement. There almost always is. I don't think that we're at an endpoint, but I think that the Enforcement Division is extremely healthy. I would speculate that we compare very nicely to other similar types of divisions in state employment.
Thank you. The guidelines set 625 as the carryover goal. You've identified that. So, and you mentioned it in your last slide as looking forward. What is the goal now? I wonder if the commission will consider adopting, based on the feedback we've received, another goal. And I'll also just add, I'm grateful for the work, and I'm grateful for quarterly reports. When these were first adopted, the idea is that we were going to get quarterly reports so we could really keep a pulse on how it was affecting not only the caseload, but the enforcement team's work and what we needed to ask for. And so I encourage those. I encourage those to continue after I'm here, but another commission gets to decide that. But 625, what next on that? What goals might be set?
I have not given up on 625. Our team has not given up on 625. That was very ambitious, obviously. We had 1,415 cases at the time that number was put out there, which is a more than 50% reduction of your active caseload. That's a big deal. So the fact that we've achieved 75% of that is huge, but I don't think that we've plateaued. I think that further reductions will take a little more time, probably, than they have in the past, although the lack of an election year will certainly help, because that was, there was a lot of volume last year that was a somewhat of an impediment, and also just activities that go along with not just focusing on specific cases. I don't know if 625 is ultimately the number that is the right number. It might even be lower than that. It might be higher. I don't know, but we are still striving for that number. We continue to strive for that number, and we will get closer to that number, I am confident, at the end of next year. How close? It's hard to. It is really hard to determine what the right number is. I know it was probably I don't know if shot in the dark is the right phrase, but it's an estimate, and that's the number that was arrived at, and it's the number that we're striving for. But whether or not that is the right number or not, it's kind of hard to tell.
Yeah, thank you for those excellent comments, Commissioner Baker, and clarification. Commissioner Wilson?
Kind of as a follow-up to some of the issues that were raised in response to Commissioner Baker. While I would agree with you, the Cal Matters story was not accurate, it doesn't reflect reality. That might be the last story that somebody might have read regarding the FPPC, because unfortunately the public is missing the opportunity to observe these hearings. But as we, bring on new commissioners, and it's kind of been implied, but it would be helpful to have in that presentation the historical overview. You touched on some of it, streamlined prep program, because amongst the staff at the FPPC, that's off the top of your head. But to the extent that history is memorialized, then 1 year, 2 years, 3 years from now, someone could look at that historical overview and say, okay, that's how this has evolved. I think that would be extremely helpful.
Okay.
Otherwise, you have new commissioners coming on. They're going to hear, your very detailed presentation, but they're not going to absorb it all. To the extent there's an historical document of some sort that they can look at, I think it would be good not only for new commissioners, but also to educate the public on how some of this progress has evolved. So, thank you.
You're welcome. Thank you.
Commissioner comment? Okay. Public comment? Excellent. Anything on the portion of the executive report that you'd like to highlight?
No, not beyond what we already referenced. So I think we're good to go from my standpoint.
Perfect. Okay. Thank you, Mr. Lindsay. Why don't we move on to Ms. Shaw, the Audits and Assistance Division?
Good afternoon, Chair and Commissioners. My report for this month is as submitted. I just wanted to highlight that we will be reporting on our discretionary audit on Form 807 next month. So the information on there is just a pre-notice for next month.
Shaw. Okay, why don't we move along to Legal Division, General Counsel Dave Bainbridge.
One scheduling thing I'll note, typically early in the year, the first month, or even at the end of the last year, we have a reg calendar that's presented to the commission. We haven't done that yet. We haven't forgot about it. We're waiting because we do have some new commissioners coming on, and we also have some reg projects that are necessitated by statutory changes. So we're tackling those first, as you saw the pre-notice one today regarding 84308. We should have a proposed reg calendar for the commission either next month or the month after. These reg calendars are not required. We do them basically as a scheduling, a way to kind of schedule our year at the start of the year. So we haven't forgot about it. We'll be bringing that to the commission in the next couple months. And if anyone is interested, we do list on our report, it's on page 14 here, the upcoming for the next 3 months, which regulations will be coming to the commission.
Great. And I want to thank California Political Attorneys Association for providing us feedback on regulations for 2025. And I would encourage any other stakeholders impacted by our regulations to provide us their comments as well. Commissioner Baker?
Thank you. I would think this is an enforcement question, but I think it's under the legal, and it's the probable cause proceedings. Would that be directed
They're
to
listed
you?
under legal because our staff conducts them. They're the hearing officers on them.
Okay. My question, and you can let me know, I think this is completely appropriate, but if it's not, I see that there's the matter regarding Evan Lowe for Assembly 2020 and the Foundation for California's Technology and Innovation. There's extensive counts. Is it possible to know now, is this a case that any of those, you can't tell from here if any of those counts qualify for double or treble the normal formula? For example, typically it's 5,000 per count. Do any of them have that? Because this looks like, is it a multi-million-dollar or $1 million potential violation?
I don't know. I haven't looked at it that
Okay.
closely to see what the violations are.
To see what that is. And what comes next? Oh, I didn't know if Director West was chiming in. Then my next question is, what comes next with a probable cause proceeding, like of that nature?
Sure. The penalty phase isn't during probable cause, so this is just the finding that moves it on through the administrative process. So then the direction from the order would be that the enforcement division will write an accusation.
Okay. And is there a predictable time frame after a probable cause proceeding, like within X amount of days, that's when that happens, or?
There has to be service, and then it goes to the enforcement division, and I don't know what their timeframe is from there.
And then I will leave it at that. I just know this is one that's been pending and under public scrutiny, and wondered what the next steps were. Thank you.
Thank you. Okay, why don't we move along to the Administrative and Technology Division Chief, Dr. Wang. Good afternoon, Dr. Wang.
Good afternoon, Chair and the Commissioner. My report is submitted as it is. I just want to point out, in December, SEI unit respond more than 9,000 email received from Form 700 email box. So they're receiving numbers of email every day right now. So we appreciate everybody's patience. We will get all the email response as soon as possible, especially regarding AB 1170.
Thank you. I know we had some concern in our last meeting back in November about our budget for this calendar year. Any updates on the budget?
Yes, so Gen 10 budget was released on timely. So the governor released a balanced budget, but all the reduction regarding the vacancy and state operations, 7.95%, all the decision has been referred to spring session. So we are, finance just directed all the department still need to spend with cautious because all the reduction decisions still pending. So we have to spend with caution, which we'll continue doing that right now.
Okay, so we're not losing the positions or those funds now. It's possible that depending on what's decided that we could this spring.
Correct, because in the proposal, a 6,500 position will be a limit, but finance didn't release which exactly 6,500 position. So all the decision will be deferred to spring session, May revision.
Yeah, I think Commissioner Wilson wanted to confirm the amount of positions.
Yeah, I was just trying to clarify the number of positions that could impact the FPPC.
FPPC, it's based on their calculation, it will be the 10 position.
Oh.
Yeah, but we ask for the exclusion because that's not correct.
Okay, thank you.
Move on to our last report, and that's going to be from the Executive Director.
Oh, just unplug that. But, so I have nothing to report except for to introduce our Communications Director, Sherry Yang, and she's going to come up and talk to us about our public service announcement campaign.
Welcome,
Hi.
Ms. Yang. Welcome to the FPPC.
Hi, good afternoon, Chair and Commissioners. So I'm really excited to be here. I just started last week and I see that there's so many great opportunities for this commission, and I'm just hearing numbers for the first time and I'm like, oh, those sounds like great stories. So other than that, I'm just reporting on a PSA program that we started last year. So this program is pretty much working with media outlets as well as digital channels throughout California during election season to release information on our filing deadlines right before primary election and general election. So we are hoping to continue this program and look more in depth into it. And hopefully when we get more numbers, provide you guys with more updates. So. Yeah.
Excellent. Well, thank you for that update.
Thanks.
And a couple other staffing announcements. I think it's worth noting we added, luckily for us, a Capitol Fellow. Ava back there, Ava Hartman, is going to be our Executive Fellow for this term. Let me make sure that I get everybody on this. Don't want to miss any of the important additions that we made. Also, another important addition who you've heard from today is our new Commission Assistant, Davina Vo. Thank you for joining us. And then lastly, I just want to congratulate Cole Smith. So Cole Smith was our executive research assistant, and now he's going to be joining the enforcement division. So thank you, Mr. Smith, for all your work as a researcher. Glad to see you're staying in-house. And then lastly, I absolutely want to recognize Commissioner Wood for the tremendous contribution she's made to the state of California. I have thoroughly enjoyed working with you on this commission for the past 9 months. I really loved hearing your analysis and perspective for the years prior to joining the commission. I was very excited that I got to join as chair while you were still on the commission. It's very important to have someone with your keen intellect and skeptical nature to really delve into some of these issues. And I thank you again for all the time that you've put into this. It's really a heavy burden that the public doesn't see. They just see you showing up for each one of these meetings, all of us showing up. They don't realize all the time that goes into preparing for it and providing such thoughtful feedback. So I want to thank you again for your service, Commissioner Wood. I'm sure the other commissioners share that sentiment. Sure, Commissioner Wilson.
I don't have a speech prepared, Commissioner Wood, but I do want to thank you for serving on the commission. It's been an honor to work with you as a colleague, and your knowledge as a scholar, as a professor, has been a real benefit to not only me, but it's been a very positive learning experience working with you, and thank you for your service.
Commissioner Baker.
Thank you. I second all the great and very well-deserved remarks and gratitude, and just add the ability that Commissioner Wood has had to make things more clear and to keep us focused when there's been a complex issue, and also to add something that none of us thought of. There's so many excellent improvements and observations and ways to resolve a path forward and recommendations that are because Commissioner Wood's background and ability to make those. And I'm just very, very grateful from them. We'll miss you. I'll miss you and hope to stay in touch.
Great. Why don't we move on to, well, before we do that, Commissioner Wood, go ahead.
I just want to say what an honor it's been. It's been such an honor to work with all of you and to work with this amazing staff and to serve the people of California in this way. And I wish you all luck in the future. And yeah, let's all stay in touch. I'm going to be bothering all of you to come speak to my seminars and things like that. I'm sorry I couldn't make it up for this last meeting. I feel a little awkward sitting here in LA doing this, but I really needed to be here this week. So thank you. And also thanks to the public for being so involved. I know that we just see a small share of the people who are interested in this as they come through for public comment, but I've learned a lot. I've learned a lot from the regulated community too, and how the things that we do affect them. So anyway, I really look forward to staying in touch and really am grateful for the opportunity. I'm grateful that Secretary Weber appointed me, and I wish my successor all the best in this great position.
Well, thank you again. How about, before we move on to item 12, any public comment on the executive reports? Hearing and seeing none. Why don't we move on to item number 12? I believe the main item that we're considering here is when to put an agenda item related to potentially extending the deadline for Form 700 filers within the general LA County area. So just to clarify, in order for that to go into place before the April deadline, we would have to have something on the February agenda noticed?
March for
Okay.
for the April 1 filing deadline, we'd want to have it up for adoption at the March meeting.
Okay. So would it be possible to get it pre-noticed in February? And then at Law and Policy, Commissioner Baker and myself can consider it in February?
We could bring it for discussion in February. Pre-noticing is not required. It would actually be post-notice. We have to notice it in early February before the meeting. So we can go ahead and do that if the commission ultimately decides that this doesn't make sense or it doesn't need to be done, we don't have to then have the reg adopted by the commission and present it to OAL. So I would say the best course of action would be for legal division to submit a draft over to OAL so that it's been noticed. And then if you'd like to come back in February and discuss it in maybe suggesting changes, and then we could bring it back again in March for adoption.
Okay, Commissioner Baker?
Thank you. If I'm still here, I'm available to help expedite it any
Way possible. One question I have is the Form 700 for leaving office. If there are some folks for whom it will be due, you know, it might be drilling down into every little person who's affected by this, but there may be some folks for whom it is due sooner. And if, when we go through this extension process, we just try to factor in if there's people who needed more time because of the emergency in Los Angeles that fit into that category, that we find a way to resolve that fairly for them and give them the same consideration. I don't know how that would play out, but if there's any Form 700s that are due before these deadlines, that we just try to encompass that as much as we can.
The deadline for leaving office is set by statute, so the commission doesn't have the authority to change that deadline.
Well, then I reverse my
Marks. Thanks.
Nonetheless, that's a great comment, because those are the people who are going to be most affected by this. It's going to be the officials who left in December who are going to have to file right now. So that's something I guess we can discuss and see what our options are. It seems like they're going to be quite limited. So Commissioner Wood?
Sorry, just a really practical thing that if there's any kind of local folks who are still watching, they could help us if we're not able to actually, you know, by statute extend any flexibility for the people who left office in December. They could help just by following up with them and reminding them at this point and trying to help them along on the process. I mean, I know everybody's got their hands full down here, but just thinking about practical ways to help people right now, you know.
Yeah, that's an excellent point. Any other comment on this item? Okay, then I'm going to ask for public comment really quick. Sounds like we're hearing and seeing none, correct? I'm going to move to adjourn. I have a second?
Second. I'll second.
Okay, Ms. Vo?
All right. Commissioner Baker?
Aye.
Commissioner Ortiz? Not here. Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Silver?
Aye.
Motion passed.
Thank you. Thank you, Chair.
Thanks, everyone. Take care.